All right, we are now live streaming, and hopefully, Ms. Nelson, you able to hear me?
Yes, I am, Judge.
Fantastic. Microphones are working. Good morning, everyone. This is a call of a trial calendar. It's a new format for me. It's not like a 1 week or 2 week trial calendar. It's a trial calendar that covers 3 jury selection days. We don't get to have jurors just when we want them. There are fixed dates for McBurney or Carnesale or Edwards or Dunaway to get jurors. And this calendar covers 3 of those jury selection dates. Those dates happen to be September 28th, October 12th, and October 25th. Hopefully you already know that because you got a copy of the calendar. I'm going to call all the positions now so that I can get announcements in terms of, you know what, actually, Judge, this is going to be a plea or it's being dismissed. And then we'll talk a little bit about those cases that are not resolving today and when they ought to be expected to be ready to be called out. And most of you, there shouldn't be any big surprises today unless cases are being resolved, because most of you have been given notice as to when you are expected to be called out. Things can change. I reserve the right to switch things around to a certain extent. Good morning, sir. But let's go through the calendar. Position 1 has pled. Position 2 is Mr. Holt. Mr. Holt here. All right, Mr. Webb, Mr. Holt has until the end of the session this morning to be here, or we will issue a bench warrant for him. Mr. Reeves, I believe, is here in custody. Mr. Reeves has Mr. Webb as counsel on positions 3 and 4, and Mr. Walker, who has joined us on the call. Good morning, Mr. Walker.
Good morning, Judge. How you doing?
I'm doing well. The question is, how are you doing, Mr. Multiple Incidences? How is this possible? You scare me.
Judge, I really don't know. I'm under quarantine now. I have grandkids and they're in school. And when I picked up my grandson last week, the school said that he was not to return for 14 days, both of them. And I said, well, what happened? And they've come in contact with children in the school that has COVID. Children have COVID. And I said, oh my God, I'm too old for this. So, and I started developing symptoms and had to go to the doctor. And but I'm, you know, I don't have COVID. I just had COVID symptoms.
Okay.
So,
well, I'm glad it's that, and I'm glad you're safe. We're gonna rewind to position 3 and 4 in a minute. Your situation, Mr. Averick, is a little different than Mr. Webb's. The most serious charges that Mr. Reeves faces are in the case you've got. Mr. Reeves has been in jail for more than 2 years. And we've got this awkward situation that Ms. Hall is going to give us an update on. With the detective, it sounds like there may be developments that could be favorable for Mr. Reeves, depending on what happens with the detective. And the same, Mr. Majeski, applies to your client, Ms. Henderson, who I think is also here. But I needed to see if there was anything new, Ms. Hall, from what you last heard.
Good morning, Your Honor.
Good morning.
So last time we were in court, I didn't have a date for a grand jury. Apparently the date has been moved to today. So they could possibly be in grand jury at this moment dealing with that case.
Okay.
Dealing with that indictment.
That situation. All right. I have not yet had a chance to speak with your colleague, Ms. Allen, but I'll do that maybe after today because there should be more information. Mr. Abate is standing. Okay. All right. So if grand jury doesn't go well for the subject of the inquiry, what is your plan, Ms. Hall? I'm trusting you've thought through this a little bit because, I mean, there's this branch in the road. If there's a no bill, then certainly there's information that I think Mr. Walker and Mr. Majeski need to get, but there's a different outcome. If there's a true bill, I don't know what you and your colleagues may have discussed about what needs to happen with position 5 and 6.
Yes, Your Honor. So I have I pretty much went through all the evidence again to see if this would possibly be able to move forward, whether if there was an actual indictment, and I believe that we could still move forward. There may be issues with the defense presenting, with my lead detective. However, I feel like we can move forward. My supervisor has a different opinion. However, we will discuss that after we know what the outcome of the day is. So
Got it.
I'm not sure where we'll land depending on the outcome of today.
So Mr. Webb and Mr. Walker, you both represent Mr. Reeves. It sounds like we'll all have more information later today. I'll ask Ms. Hall to share that information with you, Mr. Walker. It doesn't affect Mr. Webb because Mr. Webb represents Mr. Reeves on completely unrelated, much older drug cases.
Yes.
But we may need to have a teleconference
Yes.
with the lawyers to figure out what makes the most sense depending on what happens with the grand jury. And it sounds like there'll be some internal deliberations on the district attorney's side. And Ms. Hall, would the decision that your office makes as to Mr. Reeves be the same as to Ms. Henderson, or is there something funky about the evidence where you don't need the detective for one of the defendants, but you need him for the other? I know you think you may not need him for either, but.
No, there is the same.
Okay, same evidence. And so if there's an issue, it's the same issue. So Mr. Majeski, I guess we'll have you in this same loop as we're working through what the consequences are from the district attorney's perspective as to whether they're going forward or withdrawing charges. Ms. Henderson's been in about a month longer than Mr. Reeves. And it's been an inordinate amount of time that she's been in. And so I was anxious to have this be what we try next week, but that didn't make sense given what was in flux. And my commitment was to have a conversation with lawyers from the district attorney's office who are in that unit that is in front of the grand jury if something didn't happen today, but something is maybe happening today. And so I may not need to have that conversation about getting some certainty. When are we going to know more? Because Mr. Reeves and Ms. Henderson are on hold. I think understandably so as they work through this, because it could have a material effect on what happens with the case. If the district attorney's office decides that they can go forward with the case regardless of the outcome today, when would you be in a position to be ready, Ms. Hall, for positions 5 and 6? Okay. Mr. Walker, you are quarantined for how much longer?
Judge, I'll be done this week, but here's my problem. I was set to go to trial in front of Judge Bartwick. So she has her grips in my side. She has a hold of me. She got a rope around me to be with her. I have 2 murder cases in her courtroom, and I have a client that's been out there for 3 years since 2017. So I would suggest to the court that my availability, I'm looking at the 28th, the 12th would be the 25th, October.
Okay. Mr. Majeski, October 25th, if we were to, there's currently Mr. Abate and a couple of the lawyers on here have a case that I'd have go out first. If that were to resolve, does the week of October 25th work for you? Or do you have concerns, gosh, if the state still wants to go forward, there'll be so much information to digest, I couldn't be ready on October 25th.
No, I think I could be ready. I mean, for all the twists and turns, this case is not very complicated. And I think it'll be enough time that whatever happens with the grand jury, that might be jiggly stuff, it might not be.
I think that's what it is. I mean, if you get anything, it's fodder for cross-examination on one witness. So I would think that you'd be able to digest that and do what you want with it. And frankly, we're talking about a date that's a month away if we go.
And I'm also trying to explore whether or not I'm even going to try this case.
Okay.
So that'll give us time to do that.
All right. So why don't we tentatively add positions 5 and 6 to the week of October 25? And I'll be updating the list. I have October 28, which is a mistake on my email. Yeah, it's
25 or 28, Judge?
Pardon me?
I said, what, is it the 25th or the 28th?
It's the 25th, October 25th. This case, yeah, October 25th, which is a Monday. So this case will go on that list, subject to hearing from Ms. Hall after her office has had a chance to process whatever happens today.
Okay.
Mr. Majeski, do you want to speak with your client because she's here, or are you good to go and we can let her know you'll be in touch?
I'd rather get back to the jail and not go see her.
Okay, then you are good to go. Thank you for being here.
Always a pleasure, Judge. Thank you.
Same. And Mr. Walker, you are free to sign off. And we will let Judge Barwick do what she needs to do with her grips into you. May you stay healthy.
Thank you, Judge.
And we'll keep you and Mr. Majeski posted on how the 25th is shaping up.
Well, Judge, thank you very much. And you guys stay safe. I'm happy to hear your voices. I'm happy to see you. You just don't know.
Well, we're glad you're able to hear us.
Thank you, Judge.
All right. Mr. Webb, Mr. Reeves has the 2 other cases that are less serious, but we still need to work through them. I've put his position 4 as a backup type case for October 12th. So our second jury selection date. His super old case that's now 7 years old is a 1-count drug case, but there's a 4-count drug case that's from 2017. Are you ready to move forward with that if reached on October 12th?
I can be, Your Honor. I will be.
Okay. Ms. Hall, I know that's not particularly efficient if really what would resolve everything is position 5, but if what we learn is that position 5 is going away, it doesn't sound like whatever happens with the grand jury today would affect either of the drug cases. It may be with the kidnapping, armed robbery gone, you and Mr. Webb can pretty quickly resolve the 2 drug cases. But I'll let you guys sort through that. All right. All right. Anything else on Mr. Reeves from the state?
That's fine, thank you, Your Honor.
All right. Mr. Webb, do you want to speak with Mr. Reeves? He's here.
I do, Your Honor.
Okay.
There is an offer on the table from the state. I'm going to make sure that he knows what it is.
For your 2 cases.
Yes, sir.
Great. Okay. And if that's something we do today, that's great. If not, just know that position 4 is on the short list for October 12th.
Just 4, not the other one.
Not 3.
Not 3.
No.
Okay.
I mean, I really, in theory, it's the state that gets to pick, but I think our discussion was you're fine with either and might as well go for the more serious one. Yeah. So position 4, both sides should be ready for that week of October 12th. And we'll keep Mr. Reeves up. All right. That gets us to position 7, Mr. Broughton. Mr. Broughton here. That'll be another bench warrant if he doesn't arrive while we're doing business. Oh, he's in custody. Well, that's why he didn't answer.
And I would like to speak with him. The state made an offer in that case. I communicated it at the jail. He rejected it, but I wanted him to know that the state's position was firm, so I asked my investigator.
We're bringing him out. He will come out. We will get on the record to offer his rejection of it, the consequences of that, and the fact that he needs to be ready for trial on October 12th. Okay. Mr. Hillard. Mr. Webb, the other Mr. Webb was here. There he is. How are you, Mr. Webb? Good morning. This is a case that I expect, if it's not resolved, that we'll try on October 12th. I know the state is needing to bring in witnesses from far afield. You ready to go on October 12th, Mr. Webb?
Yes, I will be. I want to read some of the evidence that the state has in its custody.
Sure. Do we need to bring Mr. Hillard out today just to let him know what's going on, or you good to go?
I'm good to go, Your Honor.
Okay. When we last met, you argued a motion. We talked about discovery. I made some rulings. Are we good with discovery? I know you wanted to review some things that the state has, and I'm confident Ms. Hall will make those available to you. Beyond your desire to review those things, are you feeling like you've got what you need?
I spoke with Ms. Hall yesterday, but there was one other thing of great importance that I need to talk to her about. I do that today, and I can get that today, then I should be great.
What is that thing of great importance?
There's a mention in the discovery from number 21 on the list of items. Number 21, check from 911 CAD radio. It's not in this step.
Okay.
So that's what I need.
All right. So I have a vague idea what that might be, but you'll talk with Ms. Hall when we take a break, and she can prioritize getting that to you or showing you where it might be in the, I appreciate you've got lots of discs and whatnot, and it may well be you've already got it. It's just not easy to find. Great. Well, Mr. Webb, if I don't hear from you through Ms. Nelson, I'm assuming that I don't need to get in the middle of any discovery issues. And when the people whose cases are listed for October 12th show up, because we'll start here in the morning and then go down to 1C or 1D. We'll go to 1D to pick the jury. We won't hear, unless you've just learned from Ms. Hall, this just in, but we won't hear from you on the 12th. This thing I've been asking for 6 months, I still don't have it. You need to flag that with Ms. Nelson well before October 12th so we can figure out what that is. Okay, Ms. Hall.
Yes, so I wanted to go ahead and just let the court, make the court aware. I received this information from Mr. Webb on yesterday, and a breakdown as to what he says he hasn't received is more than just what he just said. It's actually a list. I just want to be clear on the discovery because we have provided everything multiple times. The last time we were in court, there were 4 items that Mr. Webb said he hadn't received after going through the same list. I provided those things over a month ago. And now I received a list yesterday morning saying there were more things, but now this morning he's saying there's only one thing. I just want to be clear as to what we are missing so that we don't keep having the same issue because it changes when we get to court.
Okay.
It changes when we're out of court.
So couple things. One, I heard Mr. Webb say, I've got a list. The most important thing is number 21. And he was helping prioritize things. Number 2, now, right, this moment isn't the time we'll hash through this, but the same invitation to you, Ms. Hall, if you meet with Mr. Webb today or tomorrow, and your sense is, here we go again. This is now the 9th time I'm handing over a disc with these things on it. And you think we ought to convene, we'll just get on the phone. We don't need to bring Mr. Hillard in here and have a hearing on the record. It's procedural. I'm happy to get on the phone and say, where is X? And if I need to get this courtroom available so you can press play and a video can play there, because I know there've been some concerns about the video didn't play, or if I think I'm remembering the right case, Mr. Webb was saying, I got some interviews and it was an interview of a guy on a rape case, and this is not a rape case. And so maybe some things before you were involved got handed to before Mr. Webb was involved, and who knows what. I just want to avoid October 12th. We're ready to pick a jury. No, because I don't have X. And then you're pulling your hair out because I've given this to him 6 times. So we need to have a cutoff date before then to make sure everyone is okay. If I hear discovery concerns on the few days leading up to October 12th, I'm going to view them as waived unless it's something new. If you just found something and you give it to Mr. Webb and he says that's a problem, we'll need to work through that. But if it relates to something asked for and purportedly delivered, re-asked, redelivered, talking about it on October 12th is too late. So just make sure we get together well before October 12th if there continue to be issues. But I like the notion of the two of you sitting down, here's the case file, here's your list, and just have Mr. Webb sign something. Yes, I have all that. And then he signed it. But this morning isn't the forum for us to work through that. I understand both sides' frustration. Okay? Be ready on October 12th. Michael Reynolds. He's here. How you doing, Mr. Reynolds? Mr. Reynolds, you need a new lawyer. You don't need to find that lawyer. One will be appointed. Do we have, is Ms. Primovic on the call? Do we have someone from the public defenders on this call? That's a poor choice by the public defender's office. I know that they've resolved most of their cases on this calendar, but you were represented by the public defender and they have learned somehow that there is an issue and they cannot continue to represent you. Have they told you that? Okay. Ms. Nelson, can you reach out to Ms. Patel and see if she can get someone to join our call, please?
Yes, Judge, I'm looking, we're talking about Michael Reynolds, correct?
We are.
Looks like Mr. Webb has filed an entry of appearance on the 14th of September.
Oh, well, there we go. Mr. Webb, it would have been nice if you spoke up since you're sitting right here with me.
Sorry, Your Honor.
That's all right.
I guess if I filed an entry, I guess we got the case. I was waiting at the conference we had with the court. They indicated that they were that they had a conflict. I didn't know that the case was going to be decided, but obviously, but I'll get on it.
Well, I'm assuming that it wasn't a little gremlin that filed the entry of appearance. So,
No, obviously not.
yeah. Mr. Reynolds, your case was going to be continued anyway because of the announcement that was made when I met with the lawyers about this trial calendar, that the public defender's office had a conflict. Mr. Webb, who is seated there at defense counsel table, filed an entry about a week ago on your behalf. So you and Mr. Webb need to speak before you leave today so you can get his contact information and so he can get your contact information. That's going to be real essential. But because Mr. Webb is new to the case and you face some real serious charges, I do not expect Mr. Webb to be ready to defend your case during this trial calendar. It's an old case, even though you're on bond, we need to move it along. I know that the victim's family is anxious to move it along as well, and we will do that. But I, of course, need to let Mr. Webb get up to speed, get to know you, and vice versa. So that's where we are with the case. I want to make sure we still have a good address for you, Mr. Reynolds. You on Kipling Way in Riverdale? Okay, so you should get stuff in the mail telling you to be here, but you'll also be getting information from Mr. Webb when you next need to be here, okay? So please stay here. You can leave when Mr. Webb says it's okay to go. I just want to make sure you two connect and exchange information. Great. Position 10, Quindarius Jones.
Good morning, Your Honor. Desmond Humphrey, Judge. My client is present.
There we go.
Plea this morning, Your Honor. I just need to fill out the paperwork.
Fantastic. The plea sheet's up there. You and Mr. Jones can step outside and start filling that out. We'll be good to go when you're good to go.
Thank you, Judge.
Thanks for joining us. Ms. Hall, this is your case? Is it a negotiated plea?
It is.
All right, thank you. Position 11 is Melvin Henderson. Thank you. Is Mr. Bowles on the call? I don't see him. Have you been speaking with Mr. Bowles at all, Mr. Abate?
Yes, Judge. That's the proposition. Okay, we are not at work. we're resolving the case bills.
But Mr. Bowles hasn't said anything to you about not being ready. Okay. Ms. Nelson, do you mind reaching out to Mr. Bowles just to see if we could get him to plug in so I can hear him say the same thing?
I will.
Thank you. In Mr. Henderson's case, we have as an October 12th possibility, it would be behind Mr. Hillard's case, which we specially set. And we'll see what happens the week of the 25th, although I think Mr. Abate, you're already on the hook for a different murder. And as long as you know that's going, then it may be we don't get to Mr. Henderson. Okay. We'll see if we can get Mr. Bowles. James McCarver. And he is on, unlike Mr. Broughton, he is on bond. And he is not here, although you thought, Mr. Webb, it might be a plea.
I did, Your Honor, the state's offer is very reasonable, and I've made diligent attempts to contact him. I had about 6 telephone numbers. I finally reached someone who said she thought she could track him down for me. I think it was either a girlfriend or a mother, and I haven't had any contact.
Okay. Well, I know you're plugging in late and it's not a new case, but Mr. McCarver needed to keep your predecessor and you apprised of his contact information. I'm prepared to enter a bench warrant. Ms. Beza, anything from the state on Mr. McCarver's case?
No, Your Honor.
Okay. Okay, great. Mr. Webb, if Mr. McCarver calls you back and you can walk him into court so we can take the plea, I'm not going to worry about the bench warrant, but otherwise we need a way to get him plugged back into the process.
Yes, sir, I understand.
All right.
I did try.
Oh, I know you did. And that's, you got to work with what's in the file. I appreciate that. And you flagged both Mr. Holt and Mr. McCarver as folks where you would try, and you did. So, all right, Michael Robinson took a plea. So position 14 is Jabaris Hopkins. Is Mr. Hopkins here? He is. And my understanding, because I got some communication through Ms. Nelson from Mr. Thomas, that is a plea today. Is that correct?
That's correct, Your Honor. I've already sent the court the plea paper. We filled out the plea sheets. We're prepared to go. It's a negotiated plea as to just about most of the aspects of the case. You know, in other words, the state is asking a guilty plea. We're asking for an alpha plea that
Right.
far. And just one other little factor in terms of when the court might be willing to suspend the probation. But other than that, we're ready to go forward. They made the plea offer a couple of days ago, and we asked the court to take us today.
We'll do it today. Are you in a position to go forward today, Ms. Beza?
Yes, Your Honor.
Great. So you can take a seat, Mr. Hopkins. When we circle back with the calendar, we'll take that plea. It looks like we'll take a plea with Mr. Jones once he's signed up, and we'll keep moving along. Position 15 is Pedro Redamosa. Good morning, Mr. Monsiagri. How are you?
Doing well.
This is Mr. Redamosa?
Yes.
Fantastic. Now we have an interpreter here. Do we need the interpreter to have today's conversation, which is simply?
You would prefer that, Your Honor.
Great. I'm not going to swear him in because we're not getting your client on the record, but Mr. Laris, if you don't mind joining Mr. Monsiagli and Mr. Redamosa. Thank you. And good morning, Ms. Patel.
Good morning.
Mr. Monsiagli, I haven't seen you in a long time. Are you well?
I'm doing well. Yes,
Good.
thank you.
As you've hopefully heard from Ms. Nelson, this case, which was fairly far down on the list of possibilities for next Tuesday, has rocketed up to the top. Assuming Mr. Jones pleads, which it sounds like he's going to, there was the surprise plea in a murder case, and we had to move one other case. So my intention is to see you and Ms. Patel and your client on the 28th to start here, but ultimately go down to 1D and pick a jury. Is that your intention?
If it comes to that, we'll be ready. However, we are very close to a resolution of the case with a plea. Mr. Redamosa is a green card holder, so there are some immigration consequences. And we've dealt with it, a couple of them, but because I don't practice immigration law, a couple of other things that have come up that I need to speak to Ms. Patel about to see if we can come to an agreement on that. So if she's available, we can talk this morning.
She's available this morning, so definitely talk this morning. The sooner we know, the better, but really, I just would need to know, it would be great if we didn't make the jurors come all the way down here. And then on the morning of the 28th, you all announced, hey, we've sorted this out.
So it would definitely be before that.
Great. Okay. I will need voir dire from both sides by close of business tomorrow, just so I can do what I need to do over the weekend. We have Monday to work through things if there's going to be a plea. I'd prefer if there's going to be a plea, if that's how it's sorting out, that we do that today, tomorrow, or Monday. If you send me blood showing that it will be a plea, but it has to be Tuesday morning, but I can release the jurors, with enough blood, I might release the jurors. I just don't want to not have jurors if a plea falls apart. So that's why Monday would be the latest I'd want to do a plea to something other than, obviously your client can plead to the indictment, which I assume he doesn't want to do anytime during the trial.
No, I absolutely think that, I mean, it could be resolved today, tomorrow, but at the very latest Monday, it won't go into Tuesday.
Okay. Ms. Patel, anything you want to add to that dialogue?
No, we're ready to move forward today if we need to on a plea. Otherwise, we'll be ready for trial.
Okay, but are you surprised by anything Mr. Monsiagli said, or you believe that the parties are fairly close?
We are very close.
Okay. If we take a plea today, do you need folks to be here? Or would they dial in, or you're comfortable moving forward, whether it's today or tomorrow?
I'm comfortable moving forward whenever.
Okay, then when we break for today, meaning I've gone through the calendar this one time, I'd appreciate if you all would speak. Do we need to keep Mr. Lares here for the conversation, or could he go but come back if we take a plea?
For the conversation, he's not needed. I communicate to him in Spanish, but he prefers one more in court to have me the interpreter.
Sure. So Mr. Lares, if I'm making the time up, but in an hour and a half, we're in a position to take a plea in the case, would someone from your team be able to come back?
I'm hearing. Send me an email.
Okay, we'll reach out to you. But I think unless you, Mr. Monsiagli, need Mr. Lares anymore right now, he can go to handle other matters, and we'll bring him back today if we're taking a plea. And we'll certainly have someone from his team here tomorrow or Monday, if that's when the plea is happening, if a plea is happening.
Okay, that'd be great. Thank you.
Thank you. All right, 16 was dismissed. Ryan Williams. So I don't know that I excuse Mr. Williams. I know Ms. Patel filed a continuance, which I orally approved. I'll enter an order, but I'm assuming she told Mr. Williams he didn't. He's been here in court. You may not know this, but he's always been in court before. I thought he was going to be here, but we'll check with Ms. Patel. Mr. Bush entered a plea. Xavier Head. You should be in custody. All right. Mr. King, are you on the call? You are. Excellent. And then co-defendant Quentin Williams. Is Quentin Williams here? He is. Hey, Mr. Williams, your lawyer has filed leave for today, so don't panic that he's not here. We're not resolving your case today anyway, but he reminded us that many months ago, he put in for a leave that just covers this week. He'll be available for your trial, okay? Yes. Well, we can talk about that. We need your lawyer to say that again. Okay. I remember that your lawyer would need to be here for that conversation. So when he gets back, he could file something, but you should ask Mr. Melnick about that. And then he can reach out to Mr. Abate and we'll see if we can work through that, okay? But take a seat. Let's make sure we got all four defendants here. Mr. Blige, position 23 in custody.
And I'm present, Your Honor. Good morning.
Hey, how are you?
I'm doing well.
And then Mr. Rivers.
Good morning, Your Honor. Joe Brown from Mr. Rivers.
Yeah, where's your client?
He's present on the call.
I'm here, sir.
Oh, there he is. Okay, excellent. We've got everyone. This is a case that I am hoping that we try on October 25th. Mr. Abate, state going to be ready then?
Yes, sir. I will work diligently to be ready. I just want to bring to the court's attention as well as counsel. As the court knows, I'm new to the case, so I guess put some fresh eyes on it. And what I have noticed or found is the ballistics were not tested. What I'm attempting to do immediately is actually sent to a private lab because the GDI is very backed up. I think they're down to 1 or 2 firearms examiners. So I'm trying to get the ballistics tested by a private lab. I just want to bring that to everyone's attention as we move forward towards October 25th.
Okay, and in this case, do you now know enough about it that there were guns found such that ballistics are going to make a difference, or are ballistics simply going to say the bullet removed from the deceased body was a .380, but we don't have any guns, and so it might be relevant, but it's peripheral as opposed to, I'm making this up, defendant 3 had Smith & Wesson, and maybe the bullet in the deceased could be connected directly to the gun that was found on defendant number 3.
Yeah, it is not, in that case, Your Honor, there was no firearms that were recovered during this investigation, that it would just, or the relevance would be to, I guess, the number of shooters that evening, because it was a shooting that did occur in a parking lot on a Buckhead Club.
So it might be, if the ballistics showed different calibers of projectiles, that would lend credence to either there was a two-handed shooter or there must have been more than one person shooting. But it won't connect bullets recovered to firearms recovered. Okay. Let me start with Mr. King. Well, one more question for you, Mr. Abate. Mr. Pinion had informally represented that he was pretty sure if this case went to trial, the 2 defendants who would be tried would be Mr. Head and Mr. Blige, and that Mr. Rivers and Mr. Williams probably wouldn't be sitting at defense counsel table when the jury was being selected. Is that your preliminary read of the case or TBD? And I ask not for you to commit, but we are trying our first 2 defendant case in this courthouse right now. It's fine picking a jury down in 1D. It's a little crowded in 7E, but we can fit 2. Fit in 3 or 4, I'll just need to figure out some logistics about where we might try that case.
Yes, sir. I would say preliminarily, I would agree with Mr. Pinion. There may be an instance. I needed to take an opportunity to speak to both of the defense counsel for the co-defendants that are not Mr. Head or
Mr. Blige. Yep.
So I will have a conversation with them because I think Mr. Pinion's analysis is probably correct.
Okay. I mean, they're charged with very different things. Mr. Williams, who's here represented by Mr. Melnick, faces only a tampering with evidence charge. And Mr. Rivers, on our call, represented by Mr. Brown, false statement and reckless conduct. So there might even be a valid, compelling defense argument for severance. But you'll manage that. I just wanted to see where your thinking was right now. We're looking at a trial date that's a month away, so there's time for things to evolve.
And I can say confidently that Mr. Rivers would not be somebody who would be sitting at.
Okay, so you're working through the Williams situation.
Yes, Your Honor.
Okay. All right. Mr. King, first and most important, you ready to go on October 25?
I expect to, Judge. I'd like to have conversations with. I have not had any conversations with the state, but I don't see any reason why we won't be ready.
Okay. It'd be great if you and Mr. Abate speak, but that I don't know would affect your ability to be ready. It might affect whether the case is resolved or not, but I'm hearing you say that you don't see any obstacles to being ready to pick a jury on October 25. Is that a fair statement?
Yes, Judge. There's only one one issue. I've been trying to get the transcript from the preliminary hearing, and I've been unable. And so I'm hoping to be able to track that down. And but besides that, Judge, I don't have any reason why I can't be ready.
Okay. Let me ask you, and Ms. Fagan, I'm going to be asking you the same questions. Let me ask you about this ballistics information. I don't know how well you could hear Mr. Abate because he was a little bit away from a microphone because the prosecution desk was full. He has discovered that whatever projectiles were recovered, either from the deceased or from the crime scene, they've never been analyzed. And he is seeking to do that. It may go through a private lab rather than a GBI. Mr. Abate also confirmed that whatever work is done won't show this bullet came from this gun that was recovered in the case. It would simply say it was a 380 or it was a 9mm or something like that, that might shed some light on how many firearms were discharged at the scene. And he hopes to get that before trial. And if he does, he'll disclose it. And it doesn't sound like this is a case where that ballistics information is going to be so controversial that it would be understandable for you to wave your hands and say, well, wait a minute, now I need someone to test it. I need my own expert because this is the case rises and falls on the ballistics testimony. Do you agree, Mr. King, with that basic description?
Well, I don't necessarily. Yes, I do. There is no gun that was recovered from anybody in this case. So I would agree with that. What the state would try to do with whatever they recover is definitely not anything that I can respond to now, of course. So what they present, if they do test this, obviously I would have to respond at that point. But yes, I agree that, if I was a prosecutor, that's probably what my position would be. Of course, there's no cuts. So
I think that's a fair response. If Mr. Abate gets results, he'll need to push them out to everyone as quickly as possible. And then I'll just ask you, Mr. King, to flag it if that raises concerns for you. Not meaning the results concern you, but you know what, this is coming so late. I either want it excluded or I want a chance to get my own expert. And then I'll have something to process if I need to work through that. But I hear you that obviously you need to see what comes out of the expert's inquiry before you can commit one way or the other.
That's right.
Okay. Ms. Fagan, same questions. You good to go on October 25?
Yes, ready to go.
Great. I think you've been ready to go for the last year on this case, so I'm glad that hasn't changed.
Maybe two.
Maybe two. And tell me your thoughts, reaction to this discussion about the ballistics, because it sounds like it's the only, at this point, potential hiccup in discovery.
Okay, so two pieces. One is we would not be requesting a continuance based on anything that comes back on the ballistics. Two is that, well, we would be requesting that it be served by the 15th to give us days, or we'd be asking to exclude it. Then I also think it's important, since Mr. Abate is new into this case, that he's made aware that Your Honor's already said that if the state stalls in any form or fashion for this trial, that we could be heard on bond.
Okay. I don't know that I use the verb stall, but you're correct that I made plain to defense counsel, Ms. Fagan and Mr. King have been knocking at the bond door for a while. And I kept thinking we'd be able to try this case when we had these consolidated calendars, and then there was this ban on multi-defendant cases, but now we can do multi-defendant cases. So, Mr. Abate, just so you know, and I'm confident you'll be ready, but if something comes up that prompts you to say, we need more time, and it's something other than the lead detective has COVID, which could also happen on the defense side, that you'll just need to understand that a continuance, if granted, will yield a bond hearing with a little bit of a uphill slope for the state. Great. All right. I think we're all on the same page. Mr. Brown, anything you want to add on behalf of Mr. Rivers? I don't know if you were able to hear Mr. Abate, but he echoed Mr. Pinion's perspective that he really didn't see your client being going to trial.
Your Honor, I have nothing to add. I would like to speak with Mr. Abate. Just, it sounds like he has the same position as Mr. Pinion. I didn't know that Mr. Pinion was no longer on the case, but I just want to speak with Mr. Abate just to make sure that everything is as I thought it would be.
Okay, well, now you know who to talk to, and he knows who to talk to. When he is able to throw himself more into this case, I bet he'll reach out to you to try to sort that out. But I appreciate you being here. You should, unless excused or your case has been resolved, Mr. Rivers, be here in court, physically in court on October 25th. And that goes for you as well, Mr. Brown.
Yes, Your Honor.
Obviously, Ms. Fagan will be here and Mr. King will, and we'll have their clients brought over. But if Mr. Rivers hasn't already entered a plea or had his charges dismissed, he needs to show up for that appearance on the morning of October 25th. And then we'll talk about the logistics of how it is that he would not be sitting with the other defendants picking a jury. And the same goes with Mr. Williams. I'm just talking a little less about that because Mr. Melnick isn't here right now. But I think that's it. Mr. King, anything else in connection with Mr. Head?
No, Judge.
All right. Ms. Fagan, anything else in connection with Mr. Blige?
Just to clarify, the email had us second up. Are we officially first up for the 25th?
There is one case ahead of you. I haven't called it yet today. I'm going to hear, you're welcome to stay on the call. But I'm going to hear from Mr. Webb and Ms. Hall in a little bit. That case remains ahead of this one, but you all should be ready to go. And if you're not sure the likelihood of it going, you ask Mr. Abate, because I am confident he'll be working with Ms. Hall to figure out if this other case actually does stand in the way. Okay?
Got it. Thank you.
All right. And Mr. Brown, anything else on behalf of Mr. Rivers?
No, Your Honor.
All right. You all are free to go. And Mr. Williams, you're free to go. You should reach out to Mr. Melnick so he can talk to you about what we talked about today. And if he thinks it makes sense to try to modify your bond because of the curfew, he knows exactly how to do that. He'll file something and Mr. Abate will give me his thoughts on it and I'll let you know. Okay?
Stand up, sir. Stand up.
I can't hear you. If you could just come a little closer towards that big TV.
She gotta get an order from you.
Yeah, it'll come from me, but let me look at your case right now. But the way it starts is you get Mr. Melnick to send something to me. Mr. Melnick will file something because Melnick and I can't talk, just the two of us. Mr. Abate needs to be in the mix. So let me pull your case up and see if Mr. Melnick's already filed something. So I granted you a bond in March and it's got a curfew from 7 p.m. to 7 a.m. And what you're saying is I got a job now and I need to be out and about after 7 p.m. Okay, you clearly do paint. You don't seem to get much on the walls. So talk with Mr. Melnick. He knows what to file, but he has to file something and then I'll get input from Mr. Abate. But you're right, I have to enter an order, but I don't do it just because you came in here and said, hey man, I got this job painting. Give me a change to my bond. So track Mr. Melnick down. He is on leave, so if he doesn't call you back tomorrow, don't start thinking that you've got a flaky lawyer. You got a great lawyer, okay? All right, you're free to go. All right, position 25 is Ms. Boyd. She is here, so Ms. Convery has the case. maybe assisted by Mr. Parrish. And Mr. Webb, you are new to this case. It's got serious charges. And so my recollection was we were going to give you time to get ready. But you also heard Ms. Convery say, you can get ready. It is not a great case for Ms. Boyd. Not her words exactly, my words, but that's my distillation of it.
We were served discovery on it yesterday, so I'll get to work on it.
Okay. Do you want us to keep Ms. Boyd up because you're going to talk with her, or can she go? She can go.
I'll speak with her at the jail.
Okay.
I'm gonna need some time with her, so.
All right. Ms. Convery, for your preparation, I know at one point you said, look, I could be ready the week of October 25. I've elected not to include it on any list because Mr. Webb is new. I just don't think it'd be fair to Ms. Boyd, regardless of the strength of the case. It may be no amount of preparation is going to make it particularly strong for Ms. Boyd. But Mr. Webb, of course, needs to get through the case file and be in a position to offer counsel to Ms. Boyd about how best to proceed. So if that's not clear, I'm continuing this one so that Mr. Webb can be ready.
Thank you, Your Honor.
All right, and Ms. Boyd can go. Position 26, Mr. Mapp.
Excuse me, Your Honor, I'm sorry for interrupting. I just want to confirm that my client and I are excused.
You are, thank you.
Thank you very much, Your Honor.
All right, so Mr. Mapp is in custody. Mr. Arnold, I think should be able to dial in. He was having a quarantine maybe, but I don't. This is your case, Ms. Hall? Okay. Can't remember if it was you or Mr. Arnold in his email about the quarantine. Possible plea? That's not a possible plea look you just gave.
Well, we are in discussion, so he had something set up to talk with me and my supervisor, but then the quarantine thing happened.
Okay.
It got rescheduled.
All right. Well, it is on, Mr. Mapp's case is on for the week of October 25th. It's behind Head and Blige, but if Mr. Abate's case resolves, the next up is Mr. Mapp. He's been in jail for over 500 days. If he's not interested in working it out or isn't, the sides are too far apart, we need to get him into court. So that gets us to Shantoria Miller. There's Ms. Miller. This is the case that's ahead of Head and Blige. Mr. Webb, what are we doing with Ms. Miller's case?
We have a resolution for the court's consideration and approval, Your Honor.
Okay. Would that be a plea or is it?
Negotiate with Mr. Honor.
We will do that this morning. All right, Ms. Miller, you take a seat. We'll get you up here in a minute. Who is handling that for the state? Ms. Hall, great. And you agree, plea? All right. So Ms. Fagan left. Maybe hopefully she heard that. Brian Carr. Mr. Carr is here. And is Mr. Cruz? I think I saw him on the call. Yep, he's on the call. Good morning, Mr. Cruz.
Good morning to the honorable court. It's a pleasure to be here today.
Well, it's a pleasure to have you. Mr. Carr is here in court. Mr. Cruz has filed a demand for speedy trial on behalf of Mr. Carr. So that is noted. There is no clock running right now because of orders that have been entered by the chief judge. And I got a strong suspicion that that order will be extended in the coming days. That doesn't mean this is not a priority case for us. It is a backup to Mr. Mapp on the week of October 25. Are you ready to move forward with the case, Ms. Hall, if it's reached?
Yes, Your Honor, but for the fact I need to get my defendant transported from federal custody back to Fulton County from Miami.
You're a alleged victim, not defendant.
Yes.
He may be a defendant somewhere if he's in federal custody.
Yes.
You flagged that for us. That's right. So we need to figure out, is that something you need to figure out or is that something Ms. Nelson needs to figure out?
I thought it was something I need to figure out. I've been working on that, but if it.
Don't you have some team in your office why is this your issue? Don't you have people you can dispatch?
My case, so I started the process.
Okay.
And then they finished the process.
All right. And what have they said about getting this person here?
We have to go figure out exactly what it is in Miami, where it's being held, and if there's a federal custody he's in are willing to release him.
Okay.
Before they resolve whatever they have going on.
Okay.
So because it's federal custody, not just state custody, it's a bigger issue for
Mhm.
us. So I just been looking into that and hopefully we'll figure it out in the next couple of days.
Okay, well, keep me posted. That, as you know, is not Mr. Carr's issue. That's the state's issue. This trial date is over a month away, so I'm going to assume you can be ready. If you provide documentation that you've made a timely request to get this individual and the feds say, hey, it's going to take 60 days to do it, that would be a reason that I might use to move it to a subsequent trial calendar. That's not the defendant waiving his speedy trial rights or anything like that. I just have a little more leeway because the clock isn't running yet. But soon those clocks will kick in and then Mr. Carr's speedy will be running. So it behooves your office to figure out whatever the answer is. Because if the feds say, no way, you can't have him, that's a different issue. Again, not Mr. Carr's issue. But my hope is that they'll share. But you'll need to work on that. Okay. Mr. Cruz, anything you want to add on Mr. Carr's behalf?
No, sir. The news that that honorable court has entered orders that tell the speedy trial right, that is news to me. So, Your Honor, we would ask that we're placing on the calendar in the next 30 days. I want to talk to Mr. Carr about what you just advised us of and see what he would like to do as far as leaving the speedy trial in and going to trial sooner, although that timeline is told, or withdrawing the speedy trial and potentially moving the case further out.
So a couple things. One, to be clear, I'm not the one who entered the order tolling the speedy trial. The chief judge did. That's not me. And there will likely be, but don't take it to the bank, an extension of a local emergency order because the Chief Justice, the Supreme Court, has stopped tolling things. The Supreme Court has found that on a general level, speedy trial clocks could start running again. But there was a law passed by our legislature that empowers individual circuits to declare local emergencies that would toll speedy trial clocks. And that is what our chief judge has done once. It is my understanding that that will be extended for another term of court. And so any speedy trial demand that's filed, it's not a nullity, it's there, it's a marker, but it doesn't trigger any clock to run for a while longer. So I wanted to clear that up. It's not this court that did it. Second thing, I don't need to put Mr. Carr's case on a calendar for you to talk with Mr. Carr. You and Mr. Carr should talk. And if you and he conclude, Mr. Cruz, that withdrawing the speedy trial makes sense, given that he's on bond, et cetera, you should feel free to withdraw it. But if you don't, I'm going to view this as a case that we need to prioritize to try to get to trial, if that makes sense. I will be putting Mr. Carr's case on another trial calendar because that's the next stop for it. It remains on this one. It's a backup for the week of October 25th. Ms. Hall's going to try to figure out how to get this alleged victim from custody in Florida up here. We may hold on to him once he gets up here. And then I'll assume that Mr. Carr's case will roll over to our next trial calendar. So that's what I'm going to do from my end. I don't envision putting Mr. Carr's case on any other kind of calendar, unless, of course, the case is going to be resolved, and we'll put it on a plea calendar. But short of that, Mr. Carr will next hear from us, and you, Mr. Cruz, will next hear from us on the next trial calendar that the case appears on. Does that make sense?
It does make sense. It does make sense. So just to make sure I'm clear, though, and to make sure Mr. Carr is clear, we're not going to be on this trial calendar, the calendar that we just received. You're going to move us to a new trial calendar. Is that correct?
No, you remain on this calendar, and you are a backup for the week of October 25. This calendar covers 3 jury selections. And when Ms. Hall shared with my staff that it's complicated to get this guy out of Florida, I agreed to put Mr. Carr's case on our 3rd of 3 jury selection dates. So unless you hear otherwise, you, Mr. Cruz, you, Mr. Carr, you, Ms. Hall, will need to be here in courtroom 8D on the morning of October 25, because you're one of the cases that may go to trial that day. You're just not first out. In fact, ahead of you is a murder case with 2 defendants who have both said, we want to go to trial. I don't think that one's going to go away, but strange things happen. I had a murder case plead last week, so actually earlier this week. So you should be getting ready, Mr. Cruz, for trial for the week of October 25. And Ms. Hall is doing the same, and she's shared with us that she's ready, but it's hard to get this guy out of federal custody in Florida. If Mr. Carr's case is not reached on October 25, it's going to pop up on our next trial calendar. That trial calendar is going to be published soon. It will probably come out before October 25, just so everyone's getting advance notice. So you should not be surprised to see Mr. Carr on a subsequent trial calendar. That does not mean he is continued off of this trial calendar. That would only happen if I entered an order continuing it because either you, Mr. Cruz, withdrew the speedy and asked for a continuance, or Ms. Hall said, I cannot get this guy from Florida, and then I'll continue it, but that does not withdraw the speedy. That's a continuance from the state. Is that cleared up?
Yes, sir.
Excellent. Mr. Carr, do you have any questions? All right. Do we still have a good address for you? Did you get something in the mail telling you to be here? Great. You haven't moved? All right. And you understand all the conditions of your bond? They're working? All right. Ms. Hall, anything else in Mr. Carr's case?
Nothing further from the state.
All right. Mr. Cruz, thank you for joining us. And Mr. Carr, you are free to go. Sounds like Mr. Cruz may be reaching out to you soon.
Thank you, Mr. McBurney. Excuse me. Thank you, Honorable Judge McBurney. Excuse me. And thank you, Ms. Hall.
Not a problem. You're welcome.
Take care.
Mr. Remy. There he is. How you doing, sir? Just all right. Is Mr. Raines? I don't see him on the call. Mr. Abate. I don't see him here. Is he?
He stepped right out. He's in the, so he's in Judge Carr's cell. I can go grab him.
Okay. If you don't mind grabbing him. And Ms. Nelson, if you don't mind reaching out to Mr. Raines.
I will.
All right. Mr. Remy, you can take a seat. And then Mr. Lee, we continued. So let me circle back. We got Mr. Bowles on the call. We need Mr. Abate for that. How you doing, Mr. Bowles?
I'm well, Judge. How are you today?
I am well also. Thank you for joining us. We just needed to get an update on Melvin Henderson, but I need Mr. Abate to come back in here. So, you know, what we're going to do is see, I don't see Mr. Humphrey. Why don't we start the plea in Mr. Thomas's case, Mr. Hopkins? Why don't we do that? And then we'll pause when Mr. Abate gets in here so we can get Mr. Bowles off the call, and then keep pressing on. Mr. Thomas, I think I'm going to have Mr. Hopkins stand at the podium so you can see and hear him. Does that work for you?
Yes, sir.
All right.
Yes, sir. That'll work.
Great. Mr. Hopkins, you come on up. You're going to be at the podium. Ms. Hall, you can either be at counsel table or at the witness stand, wherever you'd like to be. Oh, it's Ms. Beza. Ms. Beza, you can be wherever you want to be.
Mr. Abate just needs 10 minutes. He's in the bottom.
That's fine. Mr. Bowles is going to sit tight and Mr. Remy is going to sit tight. So as long as he knows he needs to pop back here.
Yep, he does.
Thanks. And Ms. Patel, I think your only matter is with Mr. Monsiagli. So if you guys want to talk now, we've moved to sorting out some of these cases.
That'd be great.
All right. And if you don't mind, Mr. Hopkins, moving the monitor a little bit, if you rotate it, that way, Mr. Because that's the camera, but then the microphone is stuck there. So perfect. Now people can see you and hear you. That's great. All right, Ms. Beza, are you ready?
Yes, Your
All right, let's go on the record. This is position 14 on our trial calendar, State versus Jabaris Hopkins. It's 19 SC 165947. Mr. Hopkins, your lawyer, Mr. Thomas, has shared with me that you are prepared to enter a guilty plea at this time. Is that correct?
Yes.
Mr. Thomas is appearing remotely, which is A-OK by me, but you have a right to have Mr. Thomas standing by your side. Do you waive that right, and do you authorize us to move forward with Mr. Thomas appearing remotely?
Yes.
If at any point during the conversation we're about to have about your plea, you want to speak to him in private, will you let me know?
Yes.
We can do that. You'll need to step outside and give him a call. But there's nothing wrong with you conferring with him. I don't think anything will come up that will surprise you such that you need to speak with him privately, but you have that right. I need you to let me know if that's something you want to do. Will you do that?
Yes, I will.
All right, last thing. After Ms. Beza puts you under oath, which she's about to do, it's important that you answer her questions truthfully and completely. If at any point what she says or what I say causes you to have a question, again, you need to let me know that so that either I can answer it or Mr. Thomas can answer the question for you. Will you do that?
Yes.
Good. Then I think we're in a position to move forward. When you're ready, Ms. Beza.
One moment, Your Honor. Okay, please raise your right hand. Do you swear or affirm that the testimony you shall give before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your true, correct, and legal name?
Jabarius Hopkins.
You can put your hand down.
Okay.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 33.
You can
No, 32.
32 or 33?
32.
Okay.
I'll be 33 in December.
All right.
And how far have you gone in school?
I went to college, but didn't complete it.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged with the following offenses? Aggravated assault with a deadly weapon, possession of a firearm during commission of a felony, criminal damage to property in the first degree, and criminal damage to property in the second degree.
Yes.
And then do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And have you had enough time to speak with your lawyer, Mr. Dwight Thomas, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to speak with your attorney?
No.
Are you satisfied with his services?
Yes.
Mr. Thomas, do you waive formal reading of the indictment?
Yes, I will.
Do you waive any and all defects in the indictment?
Yes, I will.
Mr. Hopkins, have you been arrested on these charges that I just named?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No.
Has your attorney advised you of the minimum and maximum sentences for each charge that you are pleading to?
Yes.
Count 1, aggravated assault with a deadly weapon. The minimum and maximums are 1 year to 20 years. Count 2, possession of a firearm, 1 to 10. Count 3, criminal damage to property in the first degree, 1 to 10. Count 4, criminal damage to property in the second degree, 1 to 5. However, it's the state's recommendation of a global disposition of 10 years probation with the Family Violence Intervention Program and no contact with the victim listed in this case. Now, Mr. Hopkins, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in federal court?
Say it again.
Do you understand that this plea may be used to enhance sentencing in this jurisdiction and other jurisdictions like in federal court?
Okay.
All that means is if you get in trouble again, I hope you don't, but if you get in trouble again, the state, if it's a Georgia case, another state, or the feds, if it's a federal case, could use this conviction to say to a judge, wait a minute, Mr. Hopkins needs to get an enhanced penalty because he already pled guilty once to shooting someone. You understand? So it could have adverse effects if you get in trouble with it. You understand?
I do.
Great.
So can you just speak out, so yes or no?
Okay,
You understand what the judge just described?
yes,
And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea?
yes,
And do you understand that if you're placed on probation because of this case, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation?
yes,
And do you understand that you are not allowed to possess a firearm while on probation?
yes,
You understand that you are not a United States citizen. A guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would. And that is true regardless of any advice by your attorney or anyone else.
yes,
And do you understand that neither the court nor the district attorney nor your attorney has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
yes,
You understand that there may be other adverse consequences as a result of this guilty plea conviction, just as there would be conviction following trial. For example, your guilty plea conviction may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand that?
so I won't be able to get a passport or anything with this?
It may affect. So that's something your attorney can talk to you about, but your guilty plea may affect your ability to get that.
Okay,
You understand that?
yes,
And are you asking to be treated as a first offender under the provisions of the First Offender Act?
yes,
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no,
Have you ever been sentenced for any crime, felony or misdemeanor, under the provisions of the First Offender Act?
no,
And has your lawyer explained the First Offender Act to you?
I know of it.
Yes, I have. Yes, I have. I've explained it to him.
He and I'll be talking about it as well. Meaning Mr. Hopkins and I will.
The judge would definitely be talking to you about the First Offender Act, but do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender could be revoked and you could be adjudicated guilty? You understand that?
Yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you understand that if you went to trial, you have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
yes,
Now, do you understand that by pleading guilty, you are giving up the following rights? I'm going to name them. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, and the right to have the charges against you proved beyond reasonable doubt. Finally, the right to appeal if convicted of these charges.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
no,
How do you plead to the charges in the indictment?
Your Honor, we're asking the court to accept this plea under Alford versus North Carolina.
Okay. So Mr. Hopkins, you have the option of saying, I plead not guilty. You can have a trial. You can plead guilty, or you can plead guilty under Alford. But you need to answer one of those three to Ms. Bezos' question of how do you plead?
get it under offer.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes,
Are you aware that even if you do not admit guilt, this is a plea of guilty, it places you in the same position as if you were convicted by probation?
Yes,
And is this plea freely and voluntarily given?
yes,
You understand that you may only have a limited right to appeal this plea. You have 4 years from today for a felony charge and 12 months for a misdemeanor charge to file a habeas corpus petition.
yes.
Now, Your Honor, the state does not have any felony convictions for Mr. Hopkins. In addition, if this case would have proceeded to trial, the state would have expected its evidence to show that on January 20th, 2019 at 685 Cedar Avenue, the victim in this case, which is a former girlfriend of Mr. Hopkins, her name is Miss Siobhan, S-H-A-V-O-N-N-E Thompson, was home. While she was home, Miss Thompson stated to the police afterwards that she saw the defendant walking past her window, and then she heard gunshots. Gunshots hit her car, causing damage. In addition, gunshots hit her house as well. She was not injured. She was not injured. When she called 911 and when the police responded to the scene, she stated what I just told the court, and she told police that she saw the defendant, Mr. Hopkins, as the one walking past her window and then hearing the shooting. Your Honor, I've spoken with Miss Thompson in this case. She does not want to make a victim impact statement. However, she does want the court to know that she wants to be left alone. The defendant has not contacted her since the inception of this case. She wants to continue to be left alone, and she's very comfortable with the disposition that we reached today.
All right,
That is all from the state, Your Honor.
thank you. So you've relayed to me the victim's perspective. She's not plugging into the call or anything like that.
Nope.
Thank you. Good morning, Ms. Crawford.
Good morning, Judge McBurney.
How are you doing today?
I'm fine. How are you?
I am well. Do you have any felony convictions for Mr. Hopkins?
No, Judge, he has no record found.
Thank you. Mr. Thomas.
Yes, good morning again, young. Yes, can the court hear me?
Yes, sir.
Yes, Your Honor, we're asking the court to accept this plea under offer. The state will make a recommendation of probation as to these offenses. And the reason why I'm asking for an offer plea on this case, this is, I think, one of the classic cases that a court should accept a plea on offer. This court knows we had some issues about this alibi, you know, and of course with the Wells Fargo receipt and the withdrawal and the place he was at the time. And it was one of those types of alibi defenses that would get us down on the 1 yard line of impossibility, but wouldn't get us into the end zone all the way. I mean, it was very, very questionable. You know, the alibi wasn't questionable. He was there. He did make the withdrawal, but the question is it completely impossible that it could have happened? And of course, you know, in light of that, and in light of some of the text messages that I provided the state, the text messages were of a sort that, you know, on the one hand, it could show that the complaining witness had a reason to falsify, but on the other hand, those text messages also show that the defendant had a reason for vindication. So it was each way, it could go either way. And in light of that, the defendant does not want to risk that chance of going to trial and possibly being convicted, because I think the complaining witness is also a lawyer herself. And you know, he's moved on with his life. At the time, I think he was involved as a trainer, a physical fitness trainer. He also did kickboxing and things that sort. He's moved on with his life. And of course, we are asking the court to accept this plea on the offer, and we're asking that whatever probation the court imposes upon the defendant, the court gives him an opportunity to kind of return to society in being able to participate, as I mentioned to the state, to allow him to come back to the court and ask to be taken off probation so he can vote, so he can continue to participate. And I think that's very important. He has no prior record. And this was domestic situation and all that we're talking about. And I believe the alleged complaining witness now lives out of state now. So I'm asking the court to accept that. The other thing now I look at too, from the state, and I just kind of caught that, and maybe that was my oversight. When I calculated the maximum time, I calculated it 40 years because I was calculating count 2, possession of a firearm during the commission of felonies, a 5-year offense.
It is, and I'm going to get that on the record. I'm going to engage Mr. Hopkins with that. It's actually a 5 consecutive, so
Right.
I'm going to need to structure this sentence perhaps a little bit differently, but it'll be consistent with what was negotiated.
And that's how I calculated the 40. That's how I came up with 40, that it's 5 as opposed to 10.
Yep. That's okay. Ms. Beza's acknowledging she gave the wrong range, but I'll cover that with Mr. Hopkins.
Yes, sir. And other than that, I don't have anything else to add, And of course, court knows this has been a long haul with this case, and this defendant has been completely compliant with all the expectations of this court.
Okay, I appreciate it. Thank you for sharing all that. Mr. Hopkins, I need to cover a few things with you. First, you're pleading to all 4 counts. The second count, which alleges possession of a firearm during commission of a felony, Ms. Beza had described the range as 1 to 10. It's actually a 5-year sentence. It has to run consecutive to any other sentence. So if I were to, I'm making the numbers up, sentence you to 2 years on the first count, the second count would have to be 5 on top of that, which would make 7. So I can still do 10 years if I think that's the right answer. But I want to make sure that you understand that the range for count 2 is not 1 to 10. It's actually 5. There's no range. And that has to run consecutive to whatever other sentence you get. Do you understand that?
Yes.
Does that change your desire to enter a plea of guilty under Alford?
No.
You still want to go forward?
Yeah.
Okay. Make sure you speak loudly so Ms. Rivers can hear you and your attorney can hear you.
Okay.
Mr. Thomas, do you waive any issues arising from the fact that we're proceeding from a copy of the indictment?
No, sir. I don't have any issue with that, Young.
Great. Mr. Hopkins, you are entering a plea pursuant to a case that we call Alford for short. It's a U.S. Supreme Court case, North Carolina versus Alford. And that case held that it is okay for a judge like me to accept a plea of guilty even when the defendant says, you know what, I'm not saying I did all these things that the state says, but I would much rather work this out than go to trial because trial could end poorly for me. So sometimes the defendant is saying, I don't remember, or I did it, I just didn't do everything. And sometimes the defendant is saying, I wasn't even there, but I could see how a jury might think I'm there. And so I'm going to enter a guilty plea under Alford because I want to resolve it. Does that describe your situation? That you're not agreeing with what the state said happened in this case on January 20th of 2019, but you don't want to roll those dice of going to trial?
Yes, sir.
Do you understand that an Alford plea is still generally a conviction? It's like you said, guilty, but you are providing an explanation through your lawyer that I just want to work this out, but I don't agree with what the state said.
Yes, sir.
Now, it's like a conviction normally, but if I sentence you as a first offender, there's no conviction in the mix anyway. So an Alford plea when you're first offender has a slightly different effect than an Alford plea if you're not going to be first offender. I need to talk to you about first offender. That is generally an opportunity. You qualify for it because you don't have any other felony convictions. If I sentence you as a first offender, when you leave here today, you are not a convicted felon. So if you are applying for a job, trying to go back to school, applying for a passport, you don't check the box that says, I have a felony. Now, if the question is, are you under sentence? You bet you're under sentence. You are on probation and you're under sentence, but you don't have a conviction. And if you successfully complete your sentence, when you're done and you're discharged from that sentence, still no conviction, but then it's official. You're not even under sentence anymore. So that's a meaningful distinction. That is a box that remains on many forms. Do you have a felony conviction? The answer would be no, I don't, because you are a first offender under a first offender sentence. And if you successfully complete it, then there's no conviction on your record. That's the upside. It gives you a lot of flexibility to head in a productive direction. But as Ms. Beza mentioned, if while you are on your first offender probation, which is going to be fairly long, something like this happens again, or you get a DUI, or I promise you anything involving you and a gun, if that comes back to me and the state can show me that, yeah, you got arrested for something and here's some evidence that Mr. Hopkins had a gun on him or brandished a gun or fired a gun, not only do you have that new case, but I would have the ability, and I would likely exercise that ability, especially it involved a gun or anything with Ms. Thompson, to not just revoke your probation, but without a trial, because you've entered this plea, resentence you. And I don't know that I would, it would have to be real bad, whatever your new thing is. I could sentence you up to that 40 years we've been talking about. No trial. I just, hey, I found you violated your first offender sentence. I am revoking that and I am resentencing you up to X years. Done. And you go through the door you don't want to go through. So there's a downside to first offender. If you're not sure you're going to be able to keep things heading in the right direction, or your lifestyle is such that staying out of harm's way is complicated, first offender may not make sense for you. You make that call. I don't. I think you qualify for it, and I'm prepared to sentence you as a first offender. I need to be sure that you are making an informed decision, and it's not just, wow, Mr. Thomas, what you said sounds good. I want that first offender thing, because it can set you up for a pretty hard fall if it doesn't go well. You feel like you understand the benefit and the risk of first offender?
Yeah, so as far as the cons of the first offenders, is it like, I guess I want to know how small, because you said even if a DUI, even though I don't drink or anything, but like how small can the crime be, like jaywalking or something?
So I can't give you specific guidance, but the reality is you wouldn't be back in front of me if you got a traffic violation.
Okay.
If you catch new felony charges, guns, stealing, this or that, we'll probably be having a conversation about your first offender status.
Okay.
Speeding ticket, that kind of thing. We're not going to see each other.
Okay.
So that's a fair question. But it would need to be something fairly serious to motivate me and to motivate the prosecutor to start thinking about, do we want to undo this first offender opportunity? I'll tell you, everyone's preference is you go your way, you leave Ms. Thompson alone, you work, you go back to school, you have a family, whatever your dreams are, go realize them. You've earned that opportunity. I say you earned it. You didn't earn it by being involved with this, but because you've got a clean history, this is an option for you.
Okay.
So you feel like you understand the pros and the cons?
I do.
Understanding that, do you want to be sentenced as a first offender?
Yes, I do.
Okay. Mr. Hopkins, I find there's a factual basis for your plea. I appreciate you disagree with the facts, but if Ms. Thompson came in here and testified to what she shared with the police, and we've got the bullet damage to the car and the house, and I appreciate there's a partial defense, maybe with Wells Fargo, but as I understand it, and it's only limited, it's a partial defense. It's not physically impossible for you to have been at an ATM and also have rolled by this house to have done whatever happened. I think a jury could find you guilty. They might not, but all I need to find is that it would be reasonable for them to do so.
Yes.
I think they could, which is probably why you're entering an offer plea. I also find that your plea is knowing and voluntary. A voluntary plea is one where no one's forcing you to go forward. You may not be excited to be here, but no one's threatened you or twisted your arm. Is that a fair statement?
Yes.
A knowing plea is one where you've understood what we talked about, either initially or after we've answered your questions. Do you feel like you've understood, now that we've been talking for a while, everything about your plea?
Yes, sir.
Then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Hopkins, is that while you're on probation, if you have a technical violation, you get a speeding ticket, you miss a meeting with a probation officer, probation's going to work through that with you. You don't have to come see me.
Okay.
But if you catch new felony charges, probation will send that to me, and we'll have that conversation you're not going to want to have about first offender and things like that. I will follow the negotiated resolution. Your sentence as to counts 1, 3, and 4 is 5 years. Your sentence as to count 2, which has to run consecutive to the other, so I'll run it consecutive to count 1, is also 5 years. That's a total of 10. I will probate those years, so it's a sentence of 10 years probation. special condition number 1 is no contact with Ms. Thompson. You don't write her, you don't call her, try not to think about her. There's no thought police, but if you post something on your Facebook page or whatever social media you might use, even if it's like, feel bad, was in court today for my ex, you're talking about her and she sees that because she could, because it's public, that's communication.
Okay.
And if that is shared with the prosecutor and the prosecutor comes back to me, that's a reason to revoke your probation and start talking about first offender.
Okay.
So Ms. Thompson has gone her way and you need to not ever bump into her in any way or to use any intermediary. You guys may have a shared best friend. You don't talk to that person in an effort to get word, even if it's kind, hey, tell Siobhan happy birthday. Don't do that.
Yeah, I know.
She has her birthday and think it, but don't do anything about it. Okay?
Yes, sir.
The other special condition is that you complete what's called a family violence intervention program, which is a series of classes. It's a number of weeks long.
Excuse me, Your Honor. He's done that. I attached that to your plea sheet. It's Exhibit 2. He's already completed the 24 weeks of the family violence program.
Holy smokes.
I think y'all, if somewhere or another, I think bond, or otherwise he was ordered to do so. As Exhibit 2 attached to the plea sheet, I've attached the document showing that he's done that completion.
Got it. I'm just looking for, I looked at the plea sheet yesterday. I probably didn't get all the way through it. So if you sent that to Ms. Nelson, we've got it. I don't mean to have you do it twice.
Okay.
Is that something you've seen, Ms.
I
Beza?
did send the plea sheet. Actually did not open the attachment, but I would double check.
Okay.
I totally believe Mr. Thomas. We've been speaking literally.
I'm not doubting Mr. Thomas. I just don't remember seeing it. And so if it was not attached, we should just resend it. But let me look through my Ms. Nelson emails. Ms. Nelson, I didn't keep it because I knew you had it and you need to e-file it. Are you able to resend?
Yes, I'll resend it, Judge.
Thank you.
In fact, it's probably filed on Odyssey, but let me look.
Oh, well, I'm in his case, so let me look. It's not in Odyssey yet. While we're waiting on that, Mr. Hopkins, that special condition of no contact with Ms. Thompson may be the only special condition. We'll circle back in a moment. Normally, we'd pass around the indictment. Everyone would sign it. That'd be your indication that you're pleading guilty. I'm going to do that electronically with your approval. May I sign your part of the indictment electronically?
Yes. Yes.
All right. Mr. Thomas, may I sign for you electronically?
Yes, Your Honor.
And Ms. Beza, may I sign for you?
Yes, Your Honor.
Okay. Done.
I do see Mr. Thomas's attachment. It was he did complete a family violence 24-week family violence intervention program on October 5th of 2019.
Fantastic. So we're done. That will not be a special condition, just the no contact with Ms. Thompson.
Okay.
Mr. Thomas asked me to think about early termination of your probation. What I'll say is this: I am open to that, but that is something you earn with probation. If you are a low impact probationer, which I think you will be, in other words, you show up when you need to show up, you pay your supervision fee, they're going to want to close out your case because they at probation have too many clients and too many of them are a real pain. And that's who they focus on. And so what you and Mr. Thomas need to do after 2 years, it needs to be that long. Probation will be in a position to think about either making it unsupervised or even an early termination. And that request will come to me. I'll consider it, but that actually flows through probation. It wouldn't come naturally or directly from me. Probation would say, hey, Hopkins has been solid and we just soon not have to supervise him anymore. I get a report like that, unless I've got some other reason to be concerned, and I don't, I'm likely going to say, great, where do I sign? Okay?
Yes, sir.
So that one's on you. Are you working right now?
Yes, I'm doing personal training.
Like at a gym kind of thing?
Yes.
Okay. Do you do that at a gym or you go to people's places?
Both.
Okay.
I do at the gym, man.
How many hours a week do you work?
I'll say maybe 8 to 10 hours. Sometimes
Not
more.
enough.
Yeah.
Yeah.
I mean,
what else are you looking to do?
Right now, I'm just like I started a Amazon thing, trying to get that started.
What's an Amazon thing?
It's a private label Amazon, try to sell things on and just try to find other ways.
Okay.
Yes.
So you do some personal training, but that's only 8 to 10 hours a week.
Mm.
How are you making ends meet? Or you get paid $1,000 an hour?
No, it's 80 an hour.
Okay.
Yeah.
So you're making some money.
Yeah, I'm making
Okay.
some. Yeah.
All right. Ms. Beza, anything else for Mr. Hopkins's case? Mr. Thomas?
No, sir, nothing else, Your Honor. Thank you.
All right. Then I think we're done. Oh, no, we're not done. Ms. Crawford?
Yes, Judge. Good morning, Mr. Hopkins. I'm Ms. Crawford from Probation. I need to get a little information from you, and I need to give you a reporting date. First of all, can you tell me what county do you live in?
DeKalb.
DeKalb County. Okay, so I'll give you your reporting instructions. Can you give me your telephone number and your address, please?
It's 770-875-3387. My address is 5216 Main Street, Park Drive.
What city and state?
Stone Mountain, Georgia.
What's the zip code?
30088.
Okay. And you said you live in DeKalb County. So your report date will be October the 6th. October the 6th at 9 a.m. You probably want to write it down or have somebody to write it down for you.
Is that October 6th?
October 6th.
Mr. Thomas, you writing this down for him?
I'm trying to, Your Honor. I'm a little slow, but I'm trying to.
All right, we'll make sure you get it.
Yes, sir.
Okay, so it's October 6th. That's 10/6 at 9 a.m. The address is 2910-2910 Miller, that's Miller Road. That's Suite 100 in Decatur, Georgia. And I can give you my telephone number if you have any questions. It's 470-303-6860. I'm Ms. Crawford. And Mr. Hopkins, I just need an emergency contact person's name, their relationship, and telephone number.
That's my mom. I'm trying to think of a number. Her name is Barbara Hopkins. 678-755-6858.
Okay, that's all for me. Do you have any questions?
No.
Okay, thank you.
All right. So, Mr. Thomas, you will convey this information to Mr. Hopkins in an email or something, so he has a copy for himself?
Yes, sir, I will.
Excellent. Thank you so much. You're free to go.
Thank you.
Thank you, sir.
Mr. Abate, Mr. Monsiagli stood up super fast. Yes, sir.
Yes, if I can make an announcement, Your Honor. I would like for Mr. Readiness to be excused for a little while to consult with an immigration attorney and return here by 4 o'clock or earlier if he gets done sooner than that. To take a quick.
I'm looking at my schedule. I should be able to do that. 4 o'clock would be a good time if that works for Ms. Patel. I don't know her schedule.
I live here.
Excellent. I'm sure your family appreciates that. So I've got something at 3 here. And when I'm done with that, if everyone starts gathering a little before 4, assuming we're going forward, we'll pivot to that, but let's try to do that today. I have time before then, but obviously I want to give Mr. Redamosa as much time as he needs to consult with the attorney in that area.
If it happens quickly and it'll be before 3 o'clock, I can notify the board.
Sure, let's let Ms. Nelson know. Just email Ms. Nelson and she can let me know. But I'll be here. I'll just be back there. I'll be coming out here at 3 if I should come out at 2. because we can do it then, that's fantastic. Otherwise, let's aim for 4, assuming, well, we'll just see how much time Mr. Retamosa needs. And you'll help him figure out a way that he's meaningfully communicating with that immigration attorney. I'm talking about a language barrier. Like, you don't need us to provide an interpreter for that.
No.
Okay.
All the ones that he has a list of are Spanish speaking.
Fantastic. So we'll just keep our interpretive services on warm standby, and we'll get someone here once you let us know what time it's going to be this afternoon.
Yeah, okay.
All right.
Thank you.
Great. Thank you. We'll see you soon. Yes, ma'am. Uh-oh, who are you? Your last name is Reed? Oh, right. She's here to take a plea. She's not on the trial calendar, but that's right. We were going to do a plea before. I remember this was the, oh, I can't do. Yeah, I think this is. Well, I need the case number, but you need to take a seat. We'll do that. We'll talk about it. Take a seat and we'll take care of that. Mr. Abate, I've got 2 lawyers on our call that we can send on their way once. I just didn't want to talk with them without you here. No, you got called elsewhere. So we're gonna go in order. Melvin Henderson, which is Mr. Bowles. Mr. Bowles, you back? He's back. Fantastic. So you're ready to go, Mr. Bowles, with Mr. Henderson. Is that a fair statement?
That's a fair statement, Judge.
Okay. I have Mr. Henderson as a backup for the week of October 12th. I will tell you, we now have September 28th open. If anyone wants to go on September 28th. But it looks like the for sures for the 28th are now no longer for sure. But I just needed to make sure Mr. Abate and Mr. Bowles were on the same sheet that they were for now. Kind of far down the list on the 12th, but anything could happen. Mr. Abate, you're juggling a lot right now.
I will take the 28th for Mr. Henderson.
You could do the 28th?
Oh, you're talking about the 28th of this month.
Yeah.
Oh, I was thinking October. I was gonna jump.
No, an email I sent out, Ms. Nelson sent out, but it was my language, had a typo and it says October 28th. That's October 25th. But you already have Head and Blige on that one?
I'll stick with the 12th.
Okay. All right. Mr. Bowles, we're going to leave Melvin Henderson as the backup on the 12th. You should plan on being here in 8D on the 12th, unless you reach out to Ms. Nelson and she says to you, don't worry about it. But we'll have Mr. Henderson brought over for the 12th, and it will be on warm standby if one of the cases ahead of it, if the cases ahead of it end up getting resolved. Okay?
Okay.
Don't reach Mr. Henderson. It will be tippy top of our next trial calendar just because he's been in for so long. And it sounds like he is in a state right now where we could go forward with the trial.
Yes.
Okay.
Great.
All right. So October 12th it is. You all get a reminder of that anyway, and a revised list of what's going out. Okay?
Okay, Judge.
All right. Thank you, Mr. Bowles. You're free to go.
Thank you, Judge.
Mr. Remy, we've got Mr. Raines on the call. Thank you, Mr. Raines, for joining us.
I'm sorry about that, Judge. Good morning, sir. I was on a few bond Zooms in Bibb County, so I apologize for my tardiness.
Not a problem. Mr. Remy is here, and now we've got Mr. Abate. He got called to another courtroom for a bond hearing himself. So Mr. Remy's case is a backup. It's actually ahead of Mr. Henderson's because I want to keep us focused on sorting this out if it's going to sort out. Mr. Abate, you were sort of new to it, but not new because you were familiar with its history. Is this something where you and Mr. Raines have been talking about sorting it out, or your perspective is we need to try the gun count?
I know that Mr. Raines, I have not spoken to Mr. Raines, I'll be candid with the court, but I know Mr. Rao had been speaking with him, and it sounded as if this would be some sort of non-negotiated plea that would be presented to the court, where the state would offer 5 years to serve, and then Mr. Raines would make a different recommendation to the court, and it would be in the discretion of the court as to the sentence.
That's your understanding from Mr. Rao of what had been discussed.
That's correct.
Okay, Mr. Raines, tell me where you and Mr. Remy are with this, because today's a great day to do a non-negotiated plea. That's what we're calling the calendar for. How did you leave things with Mr. Rao? Do you need to speak with Mr. Abate? What's going on?
Judge, I know the state is where they are, and I think we're at a stalemate as far as a negotiated plea. As the court may know, when Mr. Remy was awaiting trial, he had did a significant amount of time. If I'm not mistaken, he almost had did right at 3 years before Judge Downs had granted our immunity motion. And I'll be frank with the court, sir, based on the Supreme Court decision on the appeal that was filed by the state, I don't think we would prevail at a trial on the possession of a firearm by a convicted felon. So my conversations with Mr. Remy was that it'll probably be in our best interest to enter a non-negotiated plea. But Judge, I'll be candid with you. I had been put down for the last 2 weeks because my daughter was exposed to COVID. So I haven't significant, I'm self-quarantined. So I haven't had a significant time to discuss with Remy what I think, the appropriate course of action should be. This is what I would like, Your Honor, if the court was inclined to do this, and I'm definitely not trying to waste the court's time, but I also want to make sure Mr. Remy understands, the ramifications of entering a guilty plea, is if I could be in person at the court's next plea and arraignment calendar, if it's before October the 12th, and it's something that I'm certain that we can resolve without a trial, because based on my reading of the Supreme Court's decision, I truly don't think we would prevail based on, the defense that we offered up at trial. So, but at the same time, sir, I don't want Mr. Remy to think I've sold him short by not have adequately spoken with him about, his case as it relates to the specific charge of possession of a firearm by a convicted felon. So, but I'm definitely just trying to be dilatory. Okay. It's just circumstances have prevented me from being able to adequately discuss the ramifications of going to trial or, taking a plea to what the Supreme Court has decided. Very clear.
Okay.
Opinion from the Supreme Court.
Understood. Well, I don't think Mr. Remy is going to think you shortchanged him in any way, given how the proceedings ended up. But I think it does make sense for him and you to have one more heart-to-heart so that he understands your perspective and can ask about it, push back at it, whatever he wants to do. I agree with your analysis, having read the Supreme Court opinion several times. And it does seem like what you're suggesting makes a lot of sense. And it sounds like that's what the state was prepared to do when the previous prosecutor had it. So yes, what I'm going to do is work with Ms. Nelson, and we will figure out a date and time when we can get everyone here personally in court. I think it makes sense, Mr. Raines, for you to be here in person. When does your quarantine end?
It ended, Judge. It ended actually on the 14th. I'm just saying during that period before we had this, before this hearing was today, I just haven't had the chance to sit. Mr. Remy, I don't know if you recall, Judge, he actually is a truck driver.
I recall he wants to go longer distances, and he can't do that right now. So he's anxious to sort this out, and then I appreciate that. So I'm going to work with Ms. Nelson. We'll set this down it'll be a plea hearing. And if that's not what's going to happen, you can simply let us know, Mr. Raines, and it will go back onto the trial calendar for October 12th. But we'll set a date before October 12th. That's a bunch of weeks away when
Yes,
we
sir.
can get you and Mr. Abate and Mr. Remy in here for what sounds like would be a non-negotiated plea to the one remaining count, which is the firearm possession count, which is what sounds like the evidence supports. So we'll get you that date and time. And then, Mr. Remy, you'll just need to make sure you and Mr. Raines talk as much as you need to talk about it before that date so that everyone's ready to go to have the discussion we need to have. Mr. Abate, does that work for you?
Yes, Your Honor.
Okay. Mr. Remy, do you have any questions about process right now? I think that's the right next step, is for you and Mr. Raines to spend some time talking through this. He'll let you know his perspective, more detail than he just provided now. And then we'll just get the three of you back in here, and we'll do what we need to do. All right. Thank you, Mr. Raines, for joining us.
Thank you, Your Honor. Yeah, sir.
You are free to go. Mr. Humphrey. Nope, he's not here. Yes, sir. You are also free to go. All right. Do we have other pleas that are ready? We don't have the right lawyers in here. Is Ms. Hall back in the jury room? If you could check. No, she went that way. You may be done, Mr. Abate.
Your Honor, I have an announcement.
Yes, sir.
Mr. McCarver is present in court, and I have just relayed the state's offer to him. He's looking at it right now. It may
Maybe
be
fine, Mr. McCarver, position 12. All right, excellent. And was that a Ms. Beza case?
It
or-
was.
It was. I'm glad you're still here. All right, so Mr. Webb, you and Mr. McCarver should keep talking. I will not issue a bench warrant.
Yes, sir.
And let's see what I've got down here. We should be able to take a plea on Mr. Jones. Is that the guy who keeps slumping over in his seat? Are you Mr. Jones? All right. And Mr. Webb, did you have a plea? You may. Ms. Miller. Ms. Miller's going to be a plea.
That's
Okay.
a plea, yes,
But we need
Your Honor. We need Ms. Hall on
Ms. Hall
that.
for that. Okay,
And then we need
great.
to bring in Mr. Broughton too, whenever Your Honor's ready.
Okay, maybe we'll do that. Mr. Holt is going to be here. He showed up and someone told him his case was closed. You're Mr. Holt. He's here. Excellent. All right, Mr. Webb, talk with Mr. Holt.
Yes, sir.
Mr. Holt, your case is ancient. I'm hoping it can be resolved. I don't know how many different lawyers you've had assigned to your case. For a while, you had someone named Ms. Snyder. I don't know if you and Ms. Snyder ever connected. She has left the conflict defender's office, and her replacement is Mr. Webb. So he's going to spend some time. He's been trying to track you down, but the case file had some old information in it. So at a very minimum, you and Mr. Webb need to exchange contact information. But he needs to share with you. I don't know if there's an offer from the state or what the situation is. You are number one out for the week of October 12th. But I'd love to move it up to September 28th since I now have nothing to try then. But we'll talk about that.
The motion for continuance too. I don't know if you're.
Oh, you did?
Yes,
Okay.
sir.
All right. Well, more important, you and Mr. Holt should connect right now.
Yes, sir.
All right. And I will not issue a bench warrant for Mr. Holt. Mr. Holt, let me make sure we've got good contact information for you.
If we can fill in for Ms. Hall for any pleas.
Okay. Fantastic. Let me just check on Mr. Holt here. Oh, this case had a trial? Okay.
The Holt case,
Yeah. So
Yes,
that's
Your
why
Honor.
it's so old, is that there was a trial and then,
reversed by the Court of Appeals and remanded.
got it. Okay.
So I think it was, the Court of Appeals decision was October 25th, 2019.
Okay.
But I
And then
think
we
the
had COVID.
pandemic hit,
Yeah.
and that's probably why it didn't make its way back onto the trial calendar for a retrial.
Yeah, boy, he's had a lot of lawyers. Mr. Holt, I've got an address for you on Rockaway Road in Atlanta. Is that still a good address? Excellent. Okay. Then you and Mr. Webb, like I said, need to exchange contact information at a minimum, and then we'll figure out what we're doing next. All right? Thanks. So Mr. Webb, if you are ready with your plea, let me see if we've got anyone sitting online. No lawyers there. But you said you did have a plea. Was that Ms. Miller?
Yes, Your Honor.
If you're ready to go, Mr. Abate has gamely offered to represent the state.
That would be great.
Or is it Ms. Beza? If it's your case, Ms. Beza, that's great. Yeah, it was just if it was Ms. Hall's case.
Ms. Hall's case. No, there's Ms. Hall, but I can fill it.
I'm happy. I'm not saying anyone with a bar card. I'm saying one of the two of you works for me, Abate or Beza. So Ms. Miller, if you would come on over and sit with Mr. Webb, please.
Judge, I gotta go to a meeting, but I'll come back.
All you have is Mr. Redamosa left? Okay, so you should go do what you want to do and just be watching your emails. I assume we'll be hearing from Mr. Monsiagli.
Yes.
Okay, and if for some reason he just writes to you, please let Ms. Nelson know. Hopefully he'll push it out to you and Ms. Nelson.
I have Ms. Nelson's cell phone number too, so.
Excellent.
Thank you.
Enjoy your meeting. You want to flip a coin?
No.
No? Okay, you sorted it out.
Is this negotiated or?
It is a negotiated plea.
Do you mind? What's the-
You've got an opportunity, Mr. Webb. It's gonna test your honesty.
It's 4 years probation.
Okay.
And she's eligible for first offender treatment.
Okay.
And I did ask Ms. Hall if she would consider reducing it to misdemeanor, and she declined, but if you want to overrule her, that's fine.
I don't think I'll overrule it.
Oh, just in time. We're gonna take the plea in Ms. Miller's case.
Okay.
Mr. Abate was reducing it to a misdemeanor.
Oh.
I tried to talk him out of it, but he said, that's not my jurisdiction. He said, stay in your lane, Judge.
Bye, Mr. Abate.
Bye.
Stay in your lane, Mr. Abate.
Oh, he was talking about to do that earlier. I said he was about to do that earlier.
No, and Mr. Webb was very honorable. Mr. Abate said, so what was the negotiated resolution? Mr. Webb thought for a minute, said 4 years probation,
Okay, I'm ready.
but I'll take the misdemeanor. All right. Ms. Rivers, are you ready? Great. Good morning, Ms. Miller. Ms. Miller, you're gonna wanna maybe slide closer to the microphone. Mr. Webb can slide over because you are soft-spoken, which is fine, but we need to make sure that Ms. Rivers can hear you. Mr. Webb tells me that you're prepared to enter a plea in your case. Is that right?
Yes, sir.
Great. Ms. Hall, the prosecutor, is going to put you under oath in just a moment. Once you're under oath, you need to be sure to answer her questions truthfully and completely. Will you do that?
Yes, sir.
You also need to be sure to let Mr. Webb or me know if you've got any questions. If someone says something that doesn't make sense, or it's different from what you and Mr. Webb have been talking about, you need to let me know that so we can make it clear to you, okay?
Yes, sir.
Great. When you're ready, Ms. Hall.
Thank you. Ms. Miller, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Shantaria Sheena Miller.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 34 and I graduated college.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with aggravated battery and aggravated assault?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Mr. Webb, about all the facts and circumstances regarding the charges in this indictment?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
And do you waive moving forward on a copy of the indictment?
We do.
Thank you. Ms. Miller, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes.
The minimum and maximum sentence for both aggravated battery and aggravated assault are both 1 to 20 years to serve. Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 4 years probation for both counts to run concurrent to each other and to stay away from the special condition that you stay away from the victim. But the court does not have to accept their recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that pleading guilty to a felony if you use, receive, possess, or transport a firearm or use a firearm in a crime, you may be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
I do plead in indictment number 20-SC-177191 to 1 count of aggravated battery and 1 count of aggravated assault.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 30 days to appeal this guilty plea conviction?
Yes.
Do you understand that for both of these felony charges, you only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Miller. Your Honor, the state is unaware of any prior felony convictions by the defendant. And had this case proceeded to trial, the state would have expected the evidence to show that on March the 28th, 2020, at 2347 Arno, ARNO Court, that's in Atlanta, Georgia, Fulton County, Ms. Miller, along with a co-defendant, Ms. Johnson, went over to this address and confronted the victim who was standing at that location, where they engaged in an altercation with her, a physical altercation. Ms. Miller began to punch and kick our victim to where the injuries that she sustained caused her to have permanent injuries to her kidneys. There's more information that happened in this case that you're aware of, Your Honor, that the defendant was eventually shot. However, that did not include or did not involve this defendant.
That's Ms. Miller's, is it your brother?
Yes.
Yeah, who I've already sentenced.
Yes.
Okay.
So it escalated, but the part that we're prosecuting Ms. Miller for is only the physical fighting and the injuries that were caused to the victim.
And Mr. Miller, the co-defendant, arrived after this initial affray with Ms. Johnson and Ms. Miller and Ms. Betton, Betton, I think is our victim.
Yes.
And then he arrived and that's the shooting.
Yes.
Okay.
I think that's all. I've spoken with the victims on this case several times. As we've been here before on the other co-defendants, she is satisfied with our resolution for everyone at this point, but she is still going through those injuries. She still hasn't fully recovered from, she actually recovered from the gunshot wounds, but still haven't recovered from being kicked in the stomach and the injuries that she sustained from the actual physical fight.
Okay.
But that is all from the state, Your Honor.
And you may have mentioned this special condition of probation, no contact with Ms. Benton?
Correct.
Okay, anything else?
That is all.
Okay, because I believe the location was actually Ms. Miller's grandfather, some relative of Ms. Miller. So it's not stay away from location. It was actually her family's property where Ms. Benton was staying. Dispute as to whether she should be there. So it's no contact with Ms. Benton, not stay away from location.
That's correct.
Okay.
Ms. Benton has since moved from that location and went back to her actual residence.
Ms. Benton?
Yes.
Okay, got it. Okay, thank you. Ms. Crawford, any felony criminal history for Ms. Miller?
No, Judge, Ms. Miller has no criminal history found.
Thank you.
You're welcome.
Mr. Webb?
Yes, Your Honor. I would just like to point out to the court, I don't know if this would be considered a variance between the allegata and the probata, but I noticed that in the recitation of the facts by Ms. Hall, she said that the basis for the aggravated battery was an injury to the kidneys, but the indictment charges a serious disfiguring to her ribs. So I just don't want the record to be incorrect as far as a factual basis goes for the plea. We will stipulate there's a factual basis for the plea of guilty to counts 1 and 2.
As long as you're comfortable with that, I'd say two things about it. One, I plan to merge count 2 into count 1. I think merger applies here.
I was
So-
hoping that, Your Honor.
So there'll be one sentence for one count. We did that in the other case, meaning the co-defendant. And I think factually it's supported and legally it's supported. Second, I'm fine as long as you're fine. I appreciate I heard ribs and whatnot. I heard kicking of the torso, which includes the ribs. So I think there's a sufficient factual basis.
I'm fine.
I think basically what's alleged in the indictment to me sounds less alarming and concerning than what it sounds like Ms. Hall believes could be proven by the medical evidence. So agree with everything you said. In particular, you're saying you're willing to stipulate that there's a factual basis that there was an aggravated battery.
Yes, Your Honor.
Okay, great. Thank you.
I was just being cautious. I'm sorry if I was
Cautious is good.
picky.
It's your client. Did you have anything else you wanted to add?
No, Your Honor, just that I hope you would accept the negotiated plea. I think it's a reasonable resolution of the case. And Ms. Miller has been cooperative. She works all night. She worked an all-night shift and came this morning.
So she's sleepy.
She's been sitting here. Yeah.
Okay. And is this one where first offender has been discussed, where first offender is being sought and opposed? Where do we land? And Ms. Hall may have mentioned that. I just didn't note the state's position.
I didn't mention it. I am aware that they are seeking that, and I don't have an objection to it.
Okay.
Yes, we're requesting first offender treatment, Your Honor.
Sounds like she's eligible. Ms. Miller is. State's not opposing it. It wasn't part of their recommendation. You're requesting first offender status.
Yes, I did discuss it with Ms. Hall, and she'd indicated she wasn't opposed to it.
Okay.
So it wasn't specific.
She's a woman of her word. That's exactly what she said. Okay, great. Ms. Miller, I have some questions for you, but my first is since this is your case, you have a right to share anything. If you want to share anything with me, is there anything you want to add? You had to say it out loud, whatever you're going to say.
No, sir.
Okay, where do you work?
Step 2 at a warehouse. I'm a supervisor.
Okay, what do they do in step 2 warehouse?
We make toys.
Toys? What kind of
Outdoor
toys? Like,
Outdoor toys, like
Oh.
picnics.
not like a
houses.
PlayStation 5?
No,
Okay.
I wish.
Yeah, all right. Oh, so like a swing set or one of the climbing
Yes,
things?
and mailboxes and things like that.
How long have you worked there?
I've been there for 4 years.
Okay, and you're a supervisor?
Yes,
Excellent. All right. Ms. Miller, where'd you go to college?
UGA.
And when did you graduate?
Graduated 2010.
All right. Do you have any questions about what we've been discussing?
No, I looked up everything. I'm aware.
Okay, all right. Mr. Webb, do you waive any issues that might arise from the fact that we're proceeding from a copy of the indictment?
I waived those. So waived, Your Honor.
And it sounds like, Mr. Webb, you agree with my analysis that count 2 ought to merge into count 1, that this
I do, Your
aggravated.
Honor, and I was thinking that, so you read my mind, I think.
Ms. Hall, any objection to merging count 2 into count 1?
No objection, Your Honor.
All right, we'll do that. Ms. Miller, I find that there's a factual basis for your plea. I've heard a lot more about the case when your brother entered his plea. And it sounds like it was a situation that escalated far beyond what you were involved with and became almost deadly. And so I explained this to your brother in particular. Everyone's fortunate, obviously Ms. Benton is the most fortunate, that we're not dealing with murder charges.
Right.
Because you would have been swept up in that. Not that you had a gun or you pulled the trigger, but it really got messy quickly. But it sounds like it was a fraught situation. And emotions were running high. Was it your father or your grandfather that Ms. Benton was involved with?
Actually, my great grandfather.
Your great grandfather.
Yes,
So
sir.
2 generations. Okay. Either way, an elderly gentleman and passions were running high. In the future, if something like that comes up, it needs to be handled in a slightly different way. And clearly your brother needs to stay away from it. But I do find there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means you've understood everything we've been talking about. It sounds like you understand it better than we do because you looked it all up. Any questions about any of it?
No, sir.
Voluntary means no one's forced you to enter this plea, and you may not be excited about it, but you're doing it of your own free will and upon advice of counsel. Is that true?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that for the time you're on probation, if you have what we call a technical violation, that's a small one. You miss a meeting, or maybe you move and you don't tell probation you move and they have trouble finding you, they might write you up. You and probation will work through that. You don't have to come back and see me. If you get arrested again for something serious, that comes back to me and we'll work through that. Or if you get up in Ms. Benton's business and she reaches out to the state and shows all these text messages from you saying, I'm going to get you lady the next time I see you, that would be violating the special condition of no contact with Ms. Benton. That's the other thing that will get you back here with me to talk about what to do with your probation. Okay. First offender, I need to talk to you about. First offender is, in your situation, primarily an opportunity. It means that you do not have a conviction. So if you're asked by your employer or you want to go get an advanced degree or anything like that, and there's that box, are you a felon? You are not. You are not while you're under sentence, and you won't be if you successfully complete your sentence. Everyone, for most offenses, can get one pass. You have a sentence and you had to deal with all this, but it doesn't show up on your history as a conviction because it's first offender status. So that's generally a good thing. There is a risk. It sounds like for you it's a slight risk, but if you get in trouble again while you're on first offender probation, the state could ask me to not just revoke some probation, but resentence you. Take away first offender and say, you know what? We misread Ms. Miller. She goes out and she's always kicking older ladies, and that's not good. And so not only does she have these new charges, Judge, you should resentence her as a felon in the case we're talking about. And I'd be authorized to do that if there was evidence that you committed a new felony. And I could sentence you far beyond what I'm doing today, whether it's 4 years probation or whatever I come up with. I could, because the range is 1 to 20, sentence you to 10 years in prison. On this case, because of the new situation you caught. So that's the risk of first offender. Like I said, it's mostly benefits. Do you think you understand how first offender works?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay, I will do that. Let me check one last thing. Ms. Hall, do you recall if you asked for this same sentence for Ms. Johnson? And why do you differentiate between the two?
The difference of, after speaking with the victim, she told me that the more aggressive fighting came from Ms. Miller, whereas Ms. Johnson kind of started the fighting but backed off of it. And so that's why we reduced her charges to misdemeanors.
Okay, I just wanted to understand your rationale. It's not my call, it's yours, and it's a recommendation. Okay, Ms. Miller, I'm going to sentence you to 3 years probation on count 1. Count 2 merges into count 1. They charge almost the same thing, and everything that the state would have to prove in count 1, they already have to prove for count 2, and you can't be convicted of the same thing twice. It's not how we do things in Georgia. So 3 years probation. I'm deviating a little bit down from what the state recommended, not because I think it's an unreasonable recommendation, but I'm just thinking through what probation is going to mean for you. And you have one of the more stable lives that I hear about when I'm dealing with folks on the criminal side. You got a job, it's a supervisory job, you have a college degree, all things you've earned. And that says to me, doesn't prove it, but it says to me, this isn't going to happen again. And whatever you did, you regret it. And you have the ability to say, I'm not going to put myself in that situation. I deal with a lot of folks who, unfortunately, when they go back home, they are back in that same situation, whether they want to or not, and their guns and drugs, and it's harder for them to navigate that. And so I think we would know in a year if things aren't going well. And so making your probation 4 years, I think 3 years is more than enough for you to demonstrate that's not happening again, have some consequences for what did happen, because this was not a minor incident. So 3 years probation. The special condition of your probation is no contact with Ms. Benton. You don't reach out to her to say sorry. You don't reach out to her to say, I wish I got both your kidneys. You don't do anything with Ms. Benton. And you don't have any intermediary do that either. So it would not be okay to have Ms. Johnson reach out to Ms. Benton on your behalf or some other family member. She goes in her direction and you just stay in your lane. You're doing your thing and let her go her way. Do you have any questions about any of that?
No, sir.
All right. In a moment, you're going to talk with Ms. Crawford, who is with probation, and she's going to get you set up with probation. But I have one more thing I need to cover with you. Normally, you'd sign the indictment. We'd pass all that paperwork around, but we try not to do that right now. Do you authorize me, Ms. Miller, to sign your indictment indicating your guilty plea on your behalf?
Yes, sir.
Mr. Webb, may I sign on your behalf?
You may, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Ms. Hall, anything else in Ms. Miller's case? Mr. Webb?
No, Your Honor.
All right,
Thank you.
Ms. Miller, I hope things go better for you going forward. And if you would answer Ms. Crawford's questions, she'll get you set up with probation. She's going to give you a reporting date and time. So Mr. Webb can write that down and give it to you on a piece of paper. So you've got it, okay?
Okay. Thank
Ms.
you.
Crawford.
Good morning, Ms. Miller. I'm Ms. Crawford from Probation. I need to get a little information from you as well as give you a report date. Can you tell me what county do you live in?
DeKalb.
DeKalb County. Okay. Mr. Webb, you can write this down. Your report date will be October the 6th at 10 a.m. Your report to 2910 Miller Road, that's Miller Road, Suite 150. My telephone number is 470-303-6860. If you have any questions, Ms. Crawford. And Ms. Miller, I need to get some information. I need to get your address.
It's 3783 North Decatur Road, apartment F.
F as in Frank?
Yes.
What city is it?
Decatur, Georgia, 30032.
And your telephone number?
404-979-0829.
Do you have an emergency contact, that person's name and relationship to you?
Yes, his name is Anthony Wright. That's my husband. It'll be 404-513-2634.
513-2634.
Yes.
Okay, do you have any questions for me?
No, ma'am.
Okay, thank you, that's it.
All right, Ms. Miller, thank you for being here. You are free to go.
All right, thank you. Thank you.
Mr. Humphrey?
Yes, Judge, I do believe we have our plea paperwork signed up, Judge, we're ready to move forward.
Fantastic. Ms. Rivers, are you good? You want to take a quick break? Yes, that works better? Yes. Okay. So, Mr. Jones, Mr. Humphrey, come to the podium, please. Let me get to the right place in the calendar here. Ms. Hall, are you ready?
I am.
Okay. This is position 10 on our trial calendar, State versus Quindarius Jones. Mr. Jones is here with his lawyer, Mr. Humphrey. Ms. Hall is here for the state. Is this a negotiated plea, Ms. Hall?
It is, Your Honor.
And is it to the charges or are things being reduced?
One thing is being reduced, and so count one is being authorized by the state, and count two is being revised by the state to from armed robbery to conspiracy to commit armed robbery, which is 16-4-8.
Okay. All right, Mr. Jones, in a moment, Ms. Hall is going to put you under oath. Once you're under oath, you've heard me say this to other people now. It's important you answer her questions truthfully and completely. If you have questions of your own, make sure you let Mr. Humphrey or me know so that we're answering whatever your concerns may be. Will you do that?
Yes, sir.
Great. And make sure both of you speak up so that Ms. Rivers can hear you. When you're ready, Ms. Hall.
Thank you. Mr. Jones, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Quindarius Jones.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
25 and GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with armed robbery being reduced by the state to conspiracy to commit armed robbery? Also been charged with aggravated assault with a deadly weapon and possession of a firearm during the commission of a felony.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
Um,
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I waive, yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes.
Do you waive moving forward on a copy of the indictment?
Yes, I waive.
Mr. Jones, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
No.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum sentence for conspiracy to commit armed robbery is 1 to 10 years to serve. The minimum maximum for aggravated assault with a deadly weapon is 1 to 20 years to serve. And the max for possession of a firearm during the commission of a felony is 5 years to serve to run consecutive to any other count. You understand?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of for a conspiracy to commit armed robbery as well as aggravated assault with a deadly weapon, both 10 years to serve 7, balance on probation. And for possession of a firearm during the commission of a felony, the state's recommendation is 5 years suspended. The court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this plea may be used? Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waived any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charges of conspiracy to commit armed robbery, aggravated assault with a deadly weapon, and possession of firearm during the commission of a felony in indictment number 18 SC 159178?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right, which is 30 days, to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Jones. Your Honor, the state is unaware of any prior convictions by the defendant, and had this case proceeded to trial, the state expected the evidence to show that on June the 9th, 2017, at 3400 Norman Berry Drive, that's East Point, Georgia, in Fulton County. I'm sorry, Your Honor. Officers were called out to Doubletree Hotel, where the victim said he had been robbed of his vehicle. He does not live in Georgia. He is from Ohio. He was going out to his vehicle to retrieve his luggage. Him and his family were staying at the hotel. He said once he got outside, he saw two individuals lurking by the bushes. They end up coming out the bushes, both individuals, which we believe one to be Mr. Wingo, who we've dealt with in the past, or we already dealt with that case in the past, and the other being Mr. Jones, came out of the bushes, both having handguns, and demanded his vehicle. Inside of his vehicle, he had his luggage that he wasn't able to get, a Rolex, an imitation of a Rolex watch that would belong to his son, a laptop, and other items. On June the 11th, 2 days later, officers spotted his vehicle, which is a 2011 maroon Infiniti. They spotted that vehicle on Children's Drive in Atlanta, Georgia. When they tried to make a stop, the driver of that vehicle, which was Mr. Jones, kept driving. Eventually, the vehicle came to a stop when he hit a postal truck, injuring the postal driver. He was apprehended by officers. There were two other individuals in the car at that time, and the officers apprehended all three, had interviews with all three individuals. The two passengers knew intimate details of this armed robbery hijacking that took place against our victim, Mr. Chris Potts. And Mr. Jones also had an interview with officers. He gave intimate details of the robbery as well, but excluded himself and pointed to co-defendant Mr. Wingo. However, at the time of this incident, and when he was arrested, he was wearing the imitation Rolex watch of our victims. There was never a lineup done with the victim and Mr. Jones. There was one done on Mr. Wingo, which same day he was calling a different vehicle, and he was also picked out of a different lineup for that vehicle because that victim knew who he was.
Mr. Wingo had another case, if I'm remembering. He had 2 carjacking cases. Okay, he's worked those up. So the evidence would show Mr. Jones was wearing the fake Rolex, regardless, not his Rolex, belonging to Mr. Potts's family. You've mentioned 4 people in the car. Wingo was not one of them.
3 total.
3 total. So
Yes.
Jones driving, 2 others who were able to tell the police a fair amount about the Potts carjacking.
Right.
Juveniles, they're not listed here in, our co-defendant is just Mr. Wingo.
Right, I don't think they're not, I mean, I'm sorry, they didn't list their birthdays in the report. I don't know, I don't think they were juveniles, but I'm not sure.
But the evidence, other than that they had knowledge of what happened and they were in the stolen car, the carjacked car, the evidence didn't connect them
Correct.
to the crime.
Correct.
Okay.
And I did leave out in one of the people who was in that vehicle was Mr. Jones's cousin. And he actually, they implicated Mr. Jones. I think I left that part out when I was saying what happened.
That was my next question.
Okay.
So Mr. Jones said, I can tell you about it, but I wasn't there. It was all Wingo. Other people said, I can tell you about it. It was Jones and Wingo.
Yes.
Okay.
I believe that is all, Your Honor.
All right. Thank you.
Sure.
Ms. Crawford, do you have any adult criminal history for Mr. Jones?
He's muted, Judge.
I'm sorry. Mr. Jones does not have a criminal history, Judge.
Thank you. And Ms. Hall, this structure of null processing the carjacking and changing the armed robbery to conspiracy to commit armed robbery, this is just a product of the negotiations, or is there something about the case that makes you think that somehow the carjacking was just Mr. Wingo, or it's just, this is how you're sorting the case out?
Well, Your Honor, the evidence against Mr. Jones would have been stronger with his co-defendant if they were tried together. Now that he is alone, it would be much more difficult for the state to prove certain things. So that's why we've come up with this negotiation and decided to no prize, but not because we don't think that he was a part or there, but the evidence is just a little different on him.
Okay, yeah, the way you've described the incident, it didn't, if you felt there was a proof issue with the carjacking, then there'd be a proof issue with the armed robbery, but this is a negotiation that resulted in this. Fine, that's what you guys do. Mr. Humphrey.
Yes, Your Honor, if I may, this is a negotiated plea, Judge. I just want to go over 2 things with you. One regarding.
Let me stop you for one moment. Other thing I should have asked, any impact statement from Mr. Potts?
No, he has since went back to Ohio. I've been in contact with him through both defendants. He was not interested in giving an impact statement. He just felt that they should face the consequences to what they did.
Mr. Wingo has. We'll see what happens with Mr. Jones. All right, thank you. Back to you, Mr. Humphrey.
Yes, Your Honor. So my client here, Mr. Quindarius Jones, Judge, this happened back in 2017. He spent 6 months.
So I've got June 2018.
I mean,
is when it
2018,
happened.
I'm sorry,
Okay.
Judge, 2018. He spent 6 months in the Fulton County Jail, Your Honor. He was granted a bond. Part of his bond was to be on intense pretrial services being observed by them. He had to check in weekly. He had to have a curfew. He has not violated that at all while he's been on this pretrial services observation. Also, Judge, he now works at the post office.
That's ironic.
Yeah, Judge. So he's grown up a lot. He has a 2-year-old daughter. How old is your daughter?
She's 1.5.
1-year-old daughter.
That who's here?
Yes, I believe she's
One
out.
who had the outburst.
What's her name? It's not outburst. She's 1.5. She's doing her thing. What's her name?
Leilani Jones.
Leilani. All right.
Yes, Judge. He helps his father. His father's president. They have a mattress company where they help deliver mattresses. He helps with that. Judge, basically what I'm saying before you is my client is here to accept responsibility for the actions that he did regarding his behavior with Mr. Wingo and what he did in his parts. Judge, we are asking, one, that he receives credit for the 3 years, 6 months in jail, and then the 3 years that he's been on supervised pretrial services. The reason I'm saying that, Your Honor, is because I spoke to his pretrial service officer, Linton, and he advised me that this is an intense program. It's almost like house arrest. He said to me that Mr. Jones had to have a curfew. He had to check in drug screens. I mean, basically he wasn't free, although he was outside of the jail. So I'm just asking for credit for that to be served, Judge. Another issue that I would like to cover as well is, since he is pleading today, Judge, would you allow him at least 3 weeks to turn himself in? That way he can put in his 2 weeks notice with the post office. And also he's in the process of buying a home so that his girlfriend and his child can have a stable environment, since he will have to do some time related to this case. Also, Your Honor, he did come to court today with the understanding he could go to prison. So, and he's been on pretrial release this entire time. I don't think he's a flight risk. Other than that, Your Honor, we just ask that you accept the plea as negotiated, allow him to go on first offender, just to have a life once he gets out, Judge.
Ms. Hall, your thoughts about Mr. Jones going into custody now versus a date in the near future?
The state doesn't have, well, I'll say this, I've spoken with Ms. Humphrey about this. He has been out of custody, on bond, I'm sorry, since, for a couple of years now. I got a new GCIC ran, there hasn't been any new arrests or anything, so I don't really have a dog in that fight. If that's I'll leave that to the court's discretion.
You don't oppose it?
I don't.
First offender. I don't know if it's eligible under conspiracy to commit armed robbery. You think it is?
Yes,
Okay.
Judge. Based upon my research, Judge, conspiracy to commit armed robbery isn't considered a serious violent felony, so it would qualify for first offender. It wouldn't qualify if it was just armed robbery.
Okay. Your thoughts? Assuming it's qualified, I'll have to do that research, and I'm not sure what I think about it anyway, even if he were eligible for it, but I am interested in your perspective.
Your Honor, usually I would strongly oppose this on these type of allegations and charges. My difficulty is that he has been out, and I've
Been doing what we would hope a first offender does.
right.
Yeah.
So I'll leave that to your discretion as well.
Okay. Mr. Jones, I'm going to ask you some questions, but I want to give you a chance to share anything, if there's anything you want to tell me about you or the situation you were in June of 2018.
Your Honor, I'm just here to accept responsibility. I got a little girl I just had, that's my main priority right now, accepting responsibility and getting back home to her.
Okay.
Have
you, I don't know if the person who was in the postal vehicle that you struck, there's Leilani, if the person in the postal vehicle that you struck is still with the Postal Service?
I'm not sure, Your Honor.
Okay, that's not someone you bumped into, so you could say, hey, man, I messed that one up. Sorry about that.
Think about it every day.
Okay.
And Judge, just may I add, I did some reaching out as well. That was actually her day before retirement.
Okay. Tough. Second to last day on the job. All right. So you do postal work and you help your dad with the mattress company.
Yes, sir.
This home makes me a little nervous. What's your plan? Are you buying this house outright, or is there going to be a mortgage?
No, it's going to be paid up.
Is it like a half-room house?
Not an apartment.
It's an apartment. Okay.
Yes, sir.
That's okay. But I mean, you and your child's mother would own it. It's not, hey, I'm getting you a lease.
Yes, sir.
Okay. Whatever the numbers are, you'd be putting down everything with no loan obligation that then your child's mother would, hey, I got to figure out how to cover this.
Yeah, I've been working 3 years straight. I got some.
You've done the math. I just wanted to make sure you're not getting into a situation that is more complicated than you meant it to be. Okay.
Yes, sir.
Mr. Humphrey, do you waive any issues that would flow from the fact that we're working off a copy of the indictment in Mr. Jones's case?
Yes, Your Honor, I'll waive.
Mr. Jones, I find there's a factual basis for your plea. It sounds like in June of 2018, you were in a very different place in your life than you are right now. I don't know if you hadn't met the young lady with whom you had a kid, or your folks weren't able to play as active a role, but you were doing stuff that could really easily get you killed, could have resulted in Mr. Potts getting killed. and maybe Mr. Wingo, but he's not who we're here to talk about today. It sounds like you understand that that was a series of bad choices. It's clearly something that persisted because you got picked up in Mr. Potts's car later, not just that night. And so it was something, whether it was the guys you were hanging out with or what, but I hope mostly for Leilani's sake that you figured out how to end that chapter. It's not easy to do. If those are the folks you've been spending time with, it's hard to end some of those connections, but I think you figured out that it'll help you to try to be in a different place. I also find that your plea is knowing and voluntary. Voluntary means, even though you're not, I'm sure, real thrilled to be here, you're here because you think entering a plea is the right thing for you to do, and Mr. Humphrey and your family have agreed with that. Is that correct?
Yes, sir.
And a knowing plea is just a plea that someone enters into fully understanding the consequences. Do you understand all the things Ms. Hall shared with you about the rights you're giving up?
Yes, sir.
Any questions about any of that?
No, sir.
Okay, then I'll accept your plea. I'm sentencing you under the Probation Options Management Act so that when you get to probation, if you have a minor violation, a technical violation, that'll be something for you and probation to work through. But if you catch new charges, felony charges, that'll come back to me and I'll work through what should happen with your probation. So, count one is dismissed by the state. Your sentence for counts 2 and 3 will be 7 years to serve. They'll run concurrently with each other. And your sentence on count 4 has to be 5 years, and it has to be consecutive to counts 2 and 3. But I will probate that. So the overall sentence is 12 to serve 7 rather than 10. I don't want to split those 5 years, probation and suspended, but I think what you're probably more focused on is the number of years to serve. That's 7. You will get credit for the custodial time that you served. And in terms of your turn-in date, I've done this before and it's worked every time except once. And I learned from that one time it didn't work. So I'm actually not signing your sentence today. If you show up, and we'll agree on the date in a minute, the date and time that you'll come back here. You actually don't go to the jail. You come back here and some deputies will take you into custody and you'll go through that door. If you show up, Mr. Humphrey's going to want to be there as well. At that date and time, your sentence is exactly what I just said. 12, serve 7, balance probated, credit for time served. If you are not there, and Mr. Humphrey has not communicated a real good reason why, hey, I'm running late, flat tire, something like that. If you're a no-show, then your sentence is 12 years to serve. So you'll buy yourself 5 years of custody by not showing up. And we'll find you. I won't, but someone's going to find you. And you will have almost doubled your sentence because you got the wild hair saying, you know what, I'm not ready to show up. So if you're having doubts about it, get your dad to bring you down here, get a bunch of strong guys to bring you down here. But I think it is a reasonable request to give you the time to get your affairs in order. There'll be some heavy days in there, but you know what's coming. Your lawyer has negotiated a reasonable outcome. It is a more lenient sentence than Mr. Wingo's. I think that makes sense. Mr. Wingo had some other business he was in the midst of. You may have as well, but that's not in front of me. I'm just working with what I got. So let me look at a calendar so we're real clear about when you and Mr. Humphrey will be back here. What about October 12th? I got to be here anyway because that's when all the cases are coming in for the jury we picked that day. Does that work for you, Mr. Humphrey?
That'll work for me, Judge.
So 9 a.m. on October 12th, you're coming back here to 8D. I'm going to add that to my calendar now in red so that we'll have the cases showing up for trial. That's what it needs to look like. Make it red. All right, it's on there. So you'll be here at 9. Don't show up with a suitcase or fancy watch or unfancy watch, because that'll all get taken away from you. Dress casually, and they'll take you into custody. Like I said, you're getting some credit, and you will be getting credit every day you're in from that day. So don't panic if you don't get to the Department of Corrections right away. You'll be at Rice Street for a little while. Is October 12th? I think that's a little more than 3 weeks. That's sufficient time, Mr. Humphrey?
Yes, Your Honor.
Okay. First offender. I need to do a little research on that. I don't want to impose a sentence that's only going to get kicked back. I need to think about it a little bit too. I'll tell you, I'm struggling with that one a little bit, not because anything you've done over the last few years. In fact, that's going to your benefit. But what you were involved with is, it's about as serious as it gets. The difference between what you got and the murder cases I get is someone pulled the trigger, and that's how close they are. And I am real happy for you and your girlfriend and Leilani that that's not how it played out. Obviously, life is going to be complicated for them because you're going to be out of picture for a little bit. But it's great that what you spent your time doing in the interim is starting a family and working hard and clearly making some money if you're going to be able to get an apartment. That all weighs in favor of saying, hey, when Mr. Jones gets out, let him have a fresh start. What weighs against it is just how serious this was and the ways it could have gone. So I'm going to take that under advisement. I'll make sure it's legally permissible to sentence Mr. Jones as a first offender. If you want to shoot Ms. Nelson a case you've already found, I'll look for one. But if you've already found one, state versus whatever, send it to Ms. Hall, Ms. Nelson, I'll get it. But I'm happy to do I'm curious. I want to learn it myself. But you'll know, Mr. Jones, when you show up on the 12th, what it's going to be, because I'll either be signing a sentence that says 12-7, or the one that says serve 12. I will tell you, it will not be a first offender sentence if you don't show up on the 12th. So the two consequences would be add 5 years, and it is not a first offender sentence. The last thing I've got is the indictment. I'm going to sign it for you electronically because that's how we're doing things. Does that work for you, Mr. Jones?
Yes, sir.
And Mr. Humphrey?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
All right, Ms. Hall, did you have anything else? I didn't put any conditions on the probation. Mr. Potts lives 1,000 miles away, so I don't think we need to. You're good?
Okay.
All right, Mr. Humphrey, anything from you?
Nothing further, Judge.
All right, Ms. Crawford, do you need to get information from Mr. Jones, or given the nature of his sentence, he's just going to report to probation or parole? Parole is what he'll get first, and that will flow into probation.
That's correct, Judge. I don't need any information.
All right. Mr. Jones, any questions?
No, sir.
All right. We'll see you on October 12th.
Yes, sir.
Keep us posted if something comes up.
I will, Your Honor. Thank you, Judge.
All right. Thank you.
Might be excused.
You and Mr. Jones are free to go. Hey. Thank you. Oh, thank you for this, Mr. Humphrey.
Thank you.
All right. We've been going for a long time. Let me see what we've still got. Mr. Holt, what are we doing with Mr. Holt's case?
Your Honor, this is what I would like to request from the court. When we had our conference about the cases on the trial calendar, I thought that the court had said it would most likely put this case on for October the 25th with a good chance that it would roll over to November due to the fact that I didn't have the client's file yet or the appellate record. Based upon that, I filed a motion for continuance in good faith on the 21st of September. And I did get the file yesterday.
Okay,
I had to make
that's progress.
Yes, sir. I had to make about a dozen emails, but we finally located it. It was in the Atlanta Circuit Public Defender's office, and they delivered it. So I began reading it last night and this morning.
Are you able to give me a quick summary on why the case came back? I don't remember.
Yes, Your Honor. I don't want to steal the state's thunder. They probably would rather me say it. But the Court of Appeals ruled that there was some improper character evidence that was admitted, And interestingly, it was good character of the victim, not
Okay.
necessarily bad character of my client. So they reversed on that point.
But whatever it wasn't, now this evidence is excluded. The judge should have suppressed the firearm. It's just the
No.
victim. I don't know if the evidence came in through the victim or some other witness, but we would need to keep out of a retrial good character evidence about the victim unless the trial unfolds in a different way.
That's correct, Your Honor. And I actually, another thing I wanted to do, if Your Honor would give me some time, I wanted to research whether or not a motion in limine may be proper regarding the charges for which he would be retried on. Since the jury did return a verdict on certain counts, but not guilty on some others, and the Court of Appeals went out of its way, I thought, in the opinion, to say that the evidence was sufficient to support the verdict on those charges, but I think there may be some arguments maybe about merger or maybe double jeopardy on a retrial of the case, the charges, of course, which the jury found him not guilty, and then the one that was merged into a guilty verdict. So with all those things considered, Your Honor, since my client is here now and I'm in contact with him, I would like to ask the court to grant my motion for continuance and put it on a November calendar. And I will work diligently to prepare and be ready for trial on that date.
All right, Ms. Hall, your thoughts about moving Mr. Holt off of this calendar to the next one at the earliest, given that Mr. Webb only now got the case file from one of his predecessors on the case?
Since they have no objection, you're still ready when reached.
Okay, and this is not a case where you need to fish alleged victim out of custody somewhere? Okay, all right. Mr. Webb, I will likely do that. You're saying that if I look in the docket, there'll be a motion for continuance in
Yes, sir.
there?
If you'd like to see the.
I trust you. It just, if it will be in there if you filed it.
Yes, sir. I should have sent a courtesy copy to Ms. Nelson. I guess I didn't think about it.
All right. So Mr. Holt, Mr. Webb understandably wants some time to get to know you, get to know the case file. There should be a fair amount in there since there was already one trial in your case. The transcript of the trial will, well, I don't know that there was a conviction and appeal. So there'll be a transcript. And so there ought to be a fairly robust record of what this case is all about. That ought to put your lawyer in a pretty good position to give you some advice on, do you want to try to work this case out? Or is it one that ought to be tried again? But he needs time to think through that. So he's given you his best assessment of what's out there. So I am going to continue this case. And you'll get notice in the mail, but you'll also hear from Mr. Webb about when it'll be on a trial calendar again. I'm not saying that it ends up as a trial. Like I said, it could be that the two sides reach an understanding. I don't know. There's serious charges. So to see if there's a middle ground in this one.
Thank you, Your Honor. I appreciate that grace from the court.
I think it's more realism, but we'll call it grace today. All right. So that's Mr. Holt. Do you need to talk with Mr. Holt more, or can he go?
He can go. He's going to call my office and make another appointment. And he actually had made one, but the other day I had to cancel it. So
okay,
we'll set that up really soon and talk about the case.
Great. Mr. Broughton, we need to bring out.
Yes, Your
because
Honor.
he wants to say no thank you to, is it Ms. Beza's case? Ms. Hall's case. Okay.
And then we had Mr. McCarver and Mr. Reed left.
Yep, we'll take care of everyone. I just going through in order. So if we could bring Mr. Broughton out. You need. Well, they're looking for a colleague. Let's get to Mr. McCarver. You're Mr. McCarver? Great. Mr. McCarver, let me look your case up to make sure we've got a good address for you. Mr. McCarver, I've got an address for you, Club Drive in Snellville. Yep, still a good place for you? All right, if you move, you need to let us know, you need to let Mr. Webb know. Otherwise, you should be getting stuff in the mail about your case, okay? All right. Mr. Webb, this case has been presented to me as one that really ought to work out. Where are we right now with Mr. McCarver?
I gave Mr. McCarver the state's offer in writing earlier, and I don't know if he had a chance to read my note and.
Well, guess what's first out on September 28th? So we do have a case to try. All right. I just want to make sure everyone knew. So it sounds like the case with Ms. Patel, Siri Patel, will be a plea later today. But Mr. McCarver's case will be the one we can pick a jury on. Aggravated battery, serious charges, and conviction would likely result in some serious prison time. I don't know what the state's offer is, but I want to get on the record your formal rejection of the offer. So why don't you, we got 1 sec. We'll get him out here in a minute. We're dealing with Mr. McCarver. If you come over here, Mr. McCarver, and stand next to Mr. Webb.
Could I ask the state to put the offer on?
That's what we're about to do.
Thank you, Your Honor.
All right, Ms. Rivers, you ready? This is position 12 on our trial calendar. It's indictment 18 SC 163444, State versus James McCarver. Mr. McCarver is here with his lawyer, Mr. Webb. Ms. Hall represents the state. Mr. McCarver is charged with 1 count of aggravated battery. Ms. Hall, what is the state's offer if Mr. McCarver wanted to resolve the case today? It's Ms. Beza.
Yeah.
All right.
Domestic violence. The state, after speaking with the victim in this case, who really only concern is to just be left alone, which she has been, the state's offer is 10 years on probation and no contact with the victim in the case.
Okay. Mr. McCarver, as I understand what Ms. Beza just said, the prosecutor on the case, if you entered a plea in this case, the state would recommend that you spend some time on probation with the main condition of probation that you have no contact with the person who's alleged to be the victim in this case, who is someone by the name of Lakia Murray. That's what the state's recommending. Do you understand what the state's recommendation is? Yes?
Yes, sir.
Okay. Do you understand that if you were to enter a plea today, I would also hear from Mr. Webb. He would make his recommendation that you and he had talked about that he felt was most reasonable. And that if I sentenced you any more severely than Mr. Webb recommended, you could withdraw your plea. So just to make up numbers, we know what the state's going to say. They're going to say probation, no jail time, 10 years probation. Mr. Webb might say 5 years probation. If I were to give you 6, 7, 8, 9, 10, anything more than 5, you could say, no, thank you. I'm not interested in doing that. After today, you may decide, I don't want to go to trial because I know what the state's going to ask for after trial is some prison time. So I'd like to enter a plea. You could do that, but you're stuck with whatever sentence I give you after today. Today, you can say no thanks if I give you more than what you asked for. But after today, whatever sentence I impose, that's the sentence you get. Do you understand that? Great. So Mr. McCarver, are you interested in entering a plea today, knowing what the state would recommend and knowing your ability to withdraw your plea?
It's kind of hard for somebody to do, John. It really is.
So I'm hearing what you're saying, and maybe you and Mr. Webb should talk about what's called an offered plea, where you are entering a plea because you think it's in your best interest to do so, but you're not agreeing with what the state says happened. And that's another way to work things out. But I want to be real clear, Mr. McCarver, I'm open to everything. If what you want is a trial and run that risk, we'll do that. In fact, next Tuesday, we'll do that.
No, yes.
Your Honor, he's indicated he'd like to enter a plea under North Carolina versus Alford.
I did want to get over.
Okay.
Or Alford versus North Carolina. I can't remember the style of the case.
State first, this one happens to be, but that's okay. So Mr. McCarver, what I'm going to do is let you and Mr. Webb talk a little bit more because it sounds like you might be inclined to do that, but I wanted to be real clear, no pressure, either time or otherwise. And so I think if you and Mr. Webb talk for just 2 more minutes about this Alford, or as much time as you want, then you can give me your definitive answer about, are we sorting this out today? Or should we get 12 people to come in here to hear all about it and decide what happened on November 14th of 2018 with you and Ms. Murray. So what I'm going to do is have you take a quick seat. You and Mr. Webb will talk. We're going to get first Mr. Broughton out here and just work through his situation. So you can sit in the first row right there, and then you and Mr. Webb can talk. And Ms. Reed, I haven't forgotten you. You are going to be after Mr. McCarver, okay? All right. Charles Webb, you're still here. You're waiting for some time with Ms. Hall? All right, you're being very patient.
Your Honor, it's interesting. My father's name was Charles Webb, and he was my law partner for several years. He's deceased. But
a different Charles Webb.
A different Charles Webb, but every time I hear the name, I think maybe I'm being haunted.
We're ready for Mr. Broughton, but I poor Sarge, I cut him off. So whenever they're ready.
Ready, Judge?
Please.
Okay. Want to sit at the table? Okay, come on.
Yeah, just sit next to counsel.
Okay, now get the table.
Okay. Ms. Hall, is this your case?
Yes, sir.
Okay, I'm now writing down. I thought I knew and I keep getting it wrong. All right. Ms. Rivers, you ready? We're going to go on the record with position 7. It's State versus Julius Broughton, 17 SC 150777. Mr. Broughton is on our trial calendar and is currently likely to be first out the week of October 12th because I just continued Mr. Holt's case. Mr. Broughton is here in court. Hello, Mr. Broughton.
How you doing, sir?
I'm okay. How are you doing?
I'm making it, sir.
You're making it. That's better than not making it. I want to make sure, Mr. Broughton, I have a AKA of Emmett Smith. Which is the name I should use for you? Broughton. Okay. So we've got the right name, Mr. Broughton. You're charged with aggravated assault, couple of drug offenses, and a couple misdemeanors from an incident that happened back in 2016. You've been in jail now for going on 520 days or so, long time. And we're looking to get you a trial if the case is not going to work out. I'm going to ask Ms. Hall to share with me on the record what the state's offer is for you so that I can make sure you understand it. And if you're not interested in that, we get that on the record as well, just to protect you and Mr. Webb so that no one could say later on, hey, Mr. Broughton didn't know what opportunities there were to resolve this case short of trial. So Ms. Hall, what is the state's recommendation if Mr. Broughton were to enter a plea today?
Your Honor, on count 1, it would be 10 years to serve $7 on probation. And that would be the highest charge.
Okay, so the net sentence would be 10 years to serve 7. Mr. Broughton would get credit for all the time he's been in, so he's already done a chunk of that. It's a parole eligible offense as of now. Is Mr. Broughton a recidivist such that if he went to trial, he would not be eligible for parole? Okay. And would you intend to recidivize Mr. Broughton so that if he were found guilty at trial, any sentence I gave him would be not eligible for parole? Okay. So Mr. Broughton, I don't know a whole lot about this case. I don't know a whole lot about you, but the state is representing to me that you have a sufficient criminal history, meaning some felony convictions, that if you went to trial, they would seek to tender those, not for the jury, but for me, if you were found guilty, such that whatever sentence I might give you after trial, if you were found guilty, would be one where you serve every day. You would not be parole eligible. The state has also explained to me that if you were to enter a plea before trial, they would not recidivize you. And they would acknowledge that you have these prior convictions, but the state has the authority to flip that switch. We want you to use those convictions to make sure no parole, or be aware of those convictions, and they help explain our recommendation, but Mr. Broughton can remain eligible for parole. Do you feel like you understand what the state's recommendation is in your case?
I do.
Okay, 10 years to serve 7, balance on probation. You also understand that this recommendation would be one where you'd be eligible for parole.
Yes, sir.
Okay, you understand that if you go to trial and you're found guilty, that's a big and, I don't know what the jury will do, but if you go to trial and you're found guilty, whatever the state recommends, it will be a non-parolable sentence.
Yes, sir.
And I'm not bound by their recommendation. I'm looking at these charges here. I don't know if the 2 aggravated assaults would merge. I don't know enough about the case, but we're talking about upwards of 40 years of exposure if the 2 aggravated assaults don't merge. If they merge, then we're looking at more than 20, 25 years exposure. I'm not saying that's the sentence you'd get, but whatever sentence I impose, it's what they call a to-the-door sentence. You would be serving all that time if you were convicted. You understand that?
Yes, sir.
Okay, sounds like you understand all this stuff.
I'm just listening to y'all understand what you're saying.
Good. I don't know how long the state would keep this offer open. They're not obligated to keep it open after today. So if you realize, dang, trial's coming up. Hey, Mr. Webb, we need to work this out. I want that 10 serve 7. Maybe Ms. Hall would continue to offer that, but she is not required to. There's no contract being formed because it's simply an offer. You can accept it today. You can say no, thank you. If you say no, thank you, we'll see what is said if you change your mind. You understand that? Understanding all those things, Mr. Bratton, are you interested in pursuing a plea today, or would you prefer that your case move to our trial calendar where we'll be picked what's on the trial calendar? Would you prefer that your case be ready to go on October 12th?
Yes, sir. I'm not willing to take the 10-7, but I'm willing to take a plea today, but just not that much time because really the aggravated assault, they won't even meet. And at the same time, I just been locked up almost 18 months. And to be honest, sir, like I had a daughter in 2017. It can't happen in 2016. My whole thought process I don't even think the same. I don't even move the same. I don't even live the same. Just being real, I don't even do the same things that we're doing then.
Now, I hear what you're saying. It resonates in particular because I just took a plea with a young man who admitted he did this stuff. And after he did it and was on bond for a while, he met the right woman, had a kid, he's got a steady job, and he just took a plea to 12-7. And it hurts, but he needs to get it behind him. And he's parole eligible. So his 7 is going to mean something less than 7. So what you're saying, I get it, that your life has changed since these allegations, and they're only allegations. Mr. Webb is free to argue for what he wants on your behalf. But in other words, it could be a non-negotiated plea. But other than to say, I'll listen to both sides, I can't tell you what I'd do if you entered a plea because I haven't heard anything about the case. What I can tell you is if I sentenced you to time in jail, it would be parole eligible now. And it wouldn't be if I sentenced you to time in jail after the trial. I think that's the biggest distinction I can draw. The state seems to think 10 serve 7 is the right fit in this case. You don't agree with that. And Mr. Webb can argue what he's going to argue on your behalf. Neither one of those binds me. I decide in the end. But that's sort of where we are. And I know it's not a good decision for you. You just need to figure out which way you want to steer the bus. Do you want to talk to Mr. Webb a little bit more or tell me what's going on?
I do want to talk to him a little more because I don't want the 7 years. I don't want to take the 10-7.
What he's not offering is you can do a non-negotiated plea. I can argue for less than 7 years if you plead guilty, and the state will argue for it, not in the judge will decide. He might give you less than 7.
All right. And I mean, there's some risk in that. Something like that. It's going to be good. Something like that. But 7 years, it's too much. It's too much.
Would you want to plead guilty and have me argue for less for 3 years? Or what if you don't mean it? Then you're stuck. She's not going to come down off of it. I already talked to her about it. She refused to reduce it from 7. So it's your decision.
if you go to trial, I don't think that's a smart decision, to be honest with you, because you get sentenced as or sentenced. So let's say even if you got 2 to 7 trial, you'd have to do 10 years. Well, I mean, even if you got 7 in trial, you'd have to do 7 years without any days. That's risky. So you tell me. Yeah.
10 years of this time. I mean, if I take the money, he could give me more.
But I don't think he will. I can't promise you that.
Take the change, but I think I'm gonna take it. He asked me to take it. I'm gonna take it.
You want to have the argument for last time?
Yes, sir.
Okay, all right, you understand. Okay.
Sir.
Your Honor, I think what we would, after discussing this with Mr. McCarver, what we would like to do, not Mr. McCarver, I'm sorry, Mr. Brott.
You've got a lot of clients today.
I have a lot of files in front of me.
And they're actually both next to you, just Mr. McCarver's a little further away.
Yes, sir. I think we would like to enter a non-negotiated plea in this case, and the state can make its recommendation, and I'll make my argument on behalf of my client, and then the court, of course, would impose the sentence.
Okay, we will do that. I want to think a little bit about scheduling. I think we can get Ms. Reed out of here in a minute, but I want to make sure we understand her intentions. And then I want you to spend a few minutes, Mr. Webb, talking with Mr. McCarver.
Yes, sir.
I know it's Mr. Broughton sitting next to you, but I want you to talk with Mr. McCarver so that you can share with me that he and you are comfortable with an offered plea, because that's what we had started talking about. But that needs to be his decision and not anyone else's. And then we should also see if we can go forward with a non-negotiated plea with Mr. Broughton. Schedule-wise, I have to take a phone call or be on a phone call at 1. So I think we could do one of the pleas before then, and then we need to take a 10 or 15-minute break. Ms. Rivers is going to need that anyway, or I'll start getting hit with court reporting equipment. So we'll probably break a little before 1, maybe for a half hour, and then we can take the other plea. And I'm happy to do it in whatever order makes the most sense. Maybe get Mr. McCarver out of here, and so do his first and then do Mr. Broughton's, but I'm not dictating the order in which we do it. But why don't we clear up Ms. Reed's situation? And then my proposal is you spend a couple minutes talking with Mr. McCarver. If he wants to go forward, we take that plea, and then we reconvene after I'm done with this call to see if that way you can talk to Mr. Broughton a little bit more and he can think through non-negotiated plea where you advocate for what he thinks is a reasonable sentence based on what you and he and I have been talking about. Does that work for you, Ms. Hall?
Yes, Your Honor.
You don't have DA meetings this afternoon? All right. Oh, and McCarver is your case, Ms. Beza. All right, so I'll get you out of here as well. So why don't we do that? Ms. Hall, if you'll stick around just while we talk about Ms. Reed's case, and then you and Mr. Webb can start your conversation. And we'll take the McCarver plea. And then Mr. Broughton, we're not forgetting about you. I just need to make sure we fit all this in. We'll bring you back out here after I'm done with my phone call that I have to be on to see what you want to do. Okay? Excellent. So, Deputy, if you would take Mr. Broughton back. Ms. Reed, if you would come on up to the podium, please. I'm just calling up your case so I can see the indictment. All right, so Ms. Reed, you, and we don't need to have this on the record, you and Mr. Hightower were charged with possession of cocaine and marijuana. And then Mr. Hightower had one more. He is a felon, so he had a different gun charge. You were given a chance to do pretrial intervention. That didn't work out well. So I had thought you were interested in entering a plea. But what I think you told me today was, you know what? I got so many cases, I lost track of which one we were talking about. I'm willing to enter a plea. And
just one more.
okay, I got this other case.
Yeah.
And that one I'm interested in working out. But this one, the one with Mr. Hightower, I'm not interested in working it out. Bring it on. My words, not yours. Okay. So Mr. Webb, you represent Ms. Reed, correct?
That's correct, Your Honor.
All right. And Ms. Hall, this is your case. All right. So we should move Ms. Reed's case to a trial calendar, it sounds like. Okay.
Speedy trial?
Pardon me?
Have like a quick trial?
So you'll want to talk to Mr. Webb about that. He can give you the legal answers about, is it too late to file a demand for speedy trial? I don't know where we are with discovery. This may be one where Ms. Hall stopped working on it because people thought that pretrial diversion would work out. But what we'll do is move it towards a trial. Mr. Webb will spend time with you, and then he will reach out to Ms. Hall to talk about, here's the things I'm missing and whatnot. And we'll see where it goes. But my goal will be to get it on a trial calendar. It may be that there is a resolution other than trial, but that's obviously something you and Mr. Webb talk about.
May I address the court on this?
You
for
may.
just a minute, Your Honor? And I want to put this on the record as an officer of the court.
Okay, hold on, because we were not on the record.
Okay.
So we'll get on the record now. So this is case 19 SC 171497. It's State versus Kenya Reed, REID. And Ms. Reed's case was a supplement to today because I think Ms. Nelson was under the impression that this was going to be a plea. And I think Ms. Reed was under the impression that it was a different case. And so she was prepared to enter a plea in that. I don't know what the other case is. We've got a case from 2019 in which Ms. Reed is charged with possessing cocaine and marijuana and a gun in connection with a gentleman by the name of Brandon Hightower. I think Mr. Hightower has already worked out his situation. And Ms. Reed maybe was going to, but it didn't play out that way. And Ms. Reed is telling me and has now twice said, I want a trial in this case. Mr. Webb, her lawyer, wants to get something on the record as an officer of the court.
Thank you, Your Honor. The last time we were in court, there was a lot of back and forth between myself and Ms. Reed and Ms. Hall. And I proposed a resolution of the case, which Ms. Hall agreed with. And if it's all right with the state, I'll put it on the record. The state was graciously willing to dismiss all of the felony drug charges and allow Ms. Reed to plead guilty to a reduced charge of misdemeanor possession of marijuana, and recommend that her sentence be commuted to time served and close the file without any probation, without any fines. I communicated this to Ms. Reed and she indicated, yes, she would accept it. And we represented that to the court, and the court then said you would put the case on for the plea, which was for today. Subsequent to that, Ms. Reed indicated to me that I think she didn't understand what the plea agreement was. And so I tried to communicate that to her several times. We had some telephone conversations, some text messages. I did make copies of the discovery in the case, and I sent that to her in the mail. The problem I ran into, and I believe I sent an email to Ms. Nelson memorializing this with a copy to Ms. Hall, was that on the telephone, when I tried to discuss the case, Mr. Hightower, who I think is either the spouse or the boyfriend, who lives with Ms. Reed, got involved and started becoming very abusive and shouting in the background and making threats and saying that she was going to have to go to trial and that the dope was his and et cetera, et cetera, et cetera.
But it was. He was just telling the
Okay,
truth.
well, hold on, but right now, Mr. Webb's talking.
Abusive.
I tried to reason with Ms. Reed. I could not get through to her. I don't know if there may be some, perhaps some mental issues there. I don't
Yeah, I
know.
told you, paranoid, schizophrenic, and bipolar. Yes, sir. I
Okay,
did.
stop. Mr. Webb's talking, then you'll
Oh,
talk.
okay. Sorry.
So as I said, she requested the discovery, which I had showed to her in court when we were here the last time. Ms. Hall gave me copies. I had the incident report and the affidavit of the arresting officer, and I showed those things to her. She asked me to mail those to her, which I did. And as I said, Mr. Hightower got involved and became very abusive, so I had to terminate the telephone conversation. And then today, when I tried to speak with her about it, Mr. Hightower was present in the hallway, and he started yelling at me and interfering and demanding that a demand for speedy trial be filed. I couldn't even communicate with Ms. Reed about that. I just terminated the conversation and came back into the courtroom. Of course, it's up to Ms. Reed what she wants to do, Your Honor, but I did want to just put this on the record, my efforts to try to resolve the case. In my opinion, having practiced criminal defense law for 42 years, it's almost a miracle that the state was willing to reduce the charge to a misdemeanor and close it out without any incarceration, and credit for the time she'd already spent in jail. But I can't seem to get that across to Ms. Reed.
Okay, I appreciate you getting all on the record. That provides more context. It's unfortunate that Mr. Hightower has decided he needs to be involved in Ms. Reed's decision, but everyone has their opinions. Ms. Reed.
Yes, sir.
So as I understand the state's offer, it's not a dismissal, but it is a plea for which there are no consequences other than there's a misdemeanor. It's not jail time, it's not probation, it's a misdemeanor marijuana resolution to the case. Is that what you understand it to be as well?
Yes.
Okay, I just want to make sure you understand it. I'm not trying to persuade you one way or the other. It's your decision in the end. It's not Mr. Hightower's decision. It's yours as to what you want to do. So as I understand it, if you accepted the state's offer, you would leave today, the case would be closed, you wouldn't have to come back, but you would have a misdemeanor on your record. And that may be something you don't want, and you don't have to have that. But that would be what you'd be going to trial over. And as long as you understand that, then I think we're on the same page.
May I ask one thing here?
Well, no, right now I'm talking with Ms. Reed. Then it'll be your turn.
Okay.
I understand, Your Honor, well, that what they're offering, and it's a good offer for someone who did the things that they're saying.
Yep.
But I didn't. And the body cam and everything will show that. So I do want a trial. So that's the only, I don't have a reason, to say, to prolong the situation or try to hide from something I did do. Cause you know what I'm saying? I got, like I said, another case that I am going to plead guilty to because I did do that.
Sure.
I did this.
Where is that case?
It's a misdemeanor case.
Okay, so it's in state court somewhere.
It's a carrying a license, a gun without my license. And, it was in the, in the process.
Sure.
But
you're going to deal with
that.
But
I didn't have it. So they, yeah. And I'm going to plead guilty to that because I did do that.
Okay. Well, that makes sense to me. And I want to be real clear. No one here is saying you need to deal with something you didn't do. Although you've heard people take these offered pleas where they say, hey, you know what? The state says X. I don't believe X, but I'm ready to get this over with.
I am ready to get it over with, but I wanted to get it over with in the right way. I have mental health issues, and
apparently a hip.
Huh?
You said you got a bad leg too.
Well, I need a knee replacement.
Knee, not hip. Okay.
So, but yes, I don't have, and then when I did take the probation, not the probation, but
pre-trial diversion.
Yes,
been a great
I
way
thought
to
it was
resolve
another case. I didn't know it was this case until I seen my Brandon Hightower name with mine, and I was like, no. And then the judge, anyway, I just wanted to take it to trial because all the evidence that the police body cam, they took the drugs out of his pocket. And it was a girl, Brandon Hightower has two girlfriends, me and another girl. She was sitting in the front seat, so why I didn't have no felonies or no misdemeanors. Why she didn't get locked up? You
Okay.
feel what I'm saying? So
I feel what you're
they
saying.
can't railroad me like that.
Nope, and no one
I
should.
just want a fair trial. That's it. You
Okay.
know.
And you are certainly entitled to that.
Thank
That's what I
you,
do,
Your
fair
Honor.
trial. So
Thank you.
what we're gonna do is return this case to moving towards trial.
Yes,
I gotta
sir.
figure out where we are in it. It sounds like, Ms. Hall, you've given all the discovery to Mr. Webb. And so we just need to see if there are any motions, and if there aren't, we can get it on a trial calendar.
Thank you, sir.
Okay? Mr. Webb, you said you had a question.
Yes, Your Honor, I
If
may
it's a
have,
question for your client, we don't need to get that on the record. If it's a question for me, you can ask me now.
I misstated. It actually wasn't a question, Your Honor. I believe that I had spoke with Ms. Hall about a possibility, but no low plea. Yeah.
I don't know.
So what we're gonna do now is stop working on this one. I think that Ms. Hall's gonna reflect on the situation. She may want to watch the body cam if there is body cam. I don't know that there is. And like I said, we'll move this case along, and there will come another point where I look to both sides to say what's happening with this case. And it may be that the answer is trial.
Yes,
It may be that Ms. Reed has thought about it more, talked with Mr. Webb, talked with Mr. Hightower, talked with Mr. Hightower's other girlfriend, and said, you know what, I want to do X, and then we'll do X. But in the meantime, we'll move the case towards trial. And that, I hear that loud and clear. So thank you.
Thank you so much. Your
All
Honor.
right. Mr. Webb, if you would spend a couple minutes talking to Mr. McCarver, we're gonna take about a 3-minute break. I need to keep it short because if we're gonna do the plea before 1, I need to get it in before 1.
Yes, sir.
And we'll do Mr. McCarver's plea. And Ms. Hall, you are free to do what you need to do till, is 1:30 okay?
That's fine, Your Honor.
Great.
Judge, what time
You guys may need to cycle through. We'll be off for about a half hour, from 1 to 1:30, where we'll be down.
Okay.
And then I gotta come back out and deal with Mr. Broughton.
Okay.
Okay? Thanks.
Were you in the full time system before?
I didn't know that Judge Ingram. As he takes life. When
Stop.
it is, it really is.
Stop. See, this
Even though
is,
COVID is still around.
yeah. So what makes it difficult is to set up. Jurors are not able to secure. So you don't. Not to see that have another judge.
Also, they deliberated an entire courtroom.
That judge has to. It's ready for them to do that.
So that enough space.
Probation. What is probation? So they can't, they don't know how to use the jury room. They probably won't be using the jury room till next year sometime.
Do they know about this?
Mid next year, they're gonna be doing this, way it's gonna be spread out.
If they don't shut it down again.
Yeah.
Who knows?
They don't have. But see, this is the thing. You look at people on TV, they talking about they don't want to get vaccinated. Or they should talk about stores where people don't want to get vaccinated. There's sometimes they die. They leaving their kids, like, it's not fair to your kids. Tomorrow is not nice to nobody. Nobody, listen up there. You know, you took vaccines when you was little, we didn't know what you was getting, what they was giving you. Did we know what we was getting when they gave us a vaccine? No.
Not all of that.
Yeah, all the vaccines, I don't know what's in the vaccine. I don't know. So, just because you amazed at the fact that they came up with this vaccine within a year's time or 6 months' time, now you're scared to death. But you see, I ain't never seen in our lifetime, have you just sit up and seen where you had all these people dying and that? It's scary, and that's how you know. I ain't trying to talk like that. So which one? It's like it's like a step between a rock and a hard. You're gonna take a vaccine that can at least prolong your life for a little while longer. And we still don't know what tomorrow's not promised based on the vaccine, or you just gonna sit there and not be vaccinated and get COVID, and then get the virus and die, just die, get sick. That's what gets me.
You need me, Mr. Webb?
No.
Oh.
Is he taking a plea?
I have no idea. I'm the prosecutor on the case.
All the inmates said it's fraud. Yeah.
It's not surveillance video doing it. Right, yeah. I came from New York. We did not.
Come to order. He was Mr.
They went with his client?
No.
The client went to the restroom.
Okay.
He just
He probably went to the restroom. So we may have nothing left. On the 28th, I did a bad job. I did not see Michael Robinson pleading out.
Neither. He actually, neither did Ms. Patel.
So Robinson was the one who changed.
Spoke over the weekend per Ms. Patel to his mother. And literally she sent me a text in the morning before she emailed Ms. Nelson at like 7. It was like, this is unbelievable. He wants to take what you've been offering the whole time.
Yeah.
They were at like 7 and we remained at 20, but
Yeah.
we did not see it at all. And I couldn't be here. But
All right. Nope, me neither. And then I figured Lee would be the backup, but then we had this wrinkle. And he agreed, the defendant he's been in jail less long than I remembered. And so that may be why, but one of his lawyers had a conflict. He got 2 good private attorneys and only one had a conflict. And I said, if we take it off this calendar, it's moving to 2022. So you need to have your client say, I will spend Thanksgiving and Christmas in jail.
Right.
So you can have your family vacation. And he did. So. But we'll be busy the other 2 weeks. Do you have anything left?
not on your calendar, no.
No. Hey, Mr. Webb.
Your Honor, I'm sorry.
I'm back because we got to finish by 1.
Yes, sir. We're ready to go forward with Mr. McCarver. I think
He went to the restroom, but if you just check out there to see if he's out there.
Yes, sir. I certainly will.
Is he going in the custody?
I don't know what the state's offer is for.
Probation.
Oh, actually, I do know what the recommendation is. Yeah, he's not.
I always like to be prepared.
Yep. Yeah, I was a little surprised. I had no idea the gentleman in the orange hoodie was going to jail. Just not today.
Yeah, that's why I knew when I heard what the.
Yeah, I saw you start moving when you heard that. It was fascinating. She said 10 to serve 7 and you started. All right, I'm gonna ask Mr. McCarver and Mr. Webb to be at the podium. It's easier for Ms. Rivers to hear folks there. Are you okay with that, Mr. McCarver, standing up at the podium? Great. He also has your voice projects very nicely. I don't know if you were in the military or what, but it sounds like a sergeant. All right.
Yes, I will.
So I'm going to get us on the record while Ms. Beza is getting her paperwork ready. Are you ready, Ms. Rivers? Okay. So this is position 12, State versus James McCarver, 18 SC 163444. Mr. McCarver, you've had a chance to speak with Mr. Webb after we got a couple things on the record, and it's my understanding that you are prepared to go forward with what we call an offered plea in your case, which has just one count of aggravated battery. Is that correct?
Yes, sir.
You had enough time to speak with Mr. Webb?
Yes, sir.
All right. Ms. Beza is going to put you under oath in just a moment. Once you're under oath, you need to answer all of her questions and mine truthfully and completely. And you also need to let me know, or Mr. Webb, if you have any questions of your own. Will you do that?
Yes, sir.
Great. Ms. Beza.
Good afternoon.
Good afternoon.
Please raise your right hand. You swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may put your hand down. Can you please state your true and correct legal name?
James Michael McCarver.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I'm 54 years old. And I graduated, I got GED. Yeah.
Are you able to read, write, and understand the English language?
Yes, ma'am.
You understand that you are charged with the following offense, count 1, aggravated battery?
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges, and plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Webb, about all of the facts and circumstances known to you regarding the charges in this indictment, including any possible defenses?
Yes, I have, ma'am.
You need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with the services?
Yes, ma'am.
Mr. Webb, do you waive formal reading of the indictment?
I do.
You waive any and all defects in the indictment?
We do.
Now, Mr. McCarver, have you been arrested on these charges?
Yes.
The state is currently unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
No, ma'am.
Has your attorney advised you the minimum and maximum sentence for each charge in the indictment?
Yes, I have.
The minimum and maximum sentence for aggravated battery is 1 year to 20 years. It's the state's recommends in prison. It's the state's recommendation for 10 years on probation. You
Yes, ma'am.
understand that?
Yes, ma'am.
Now, do you understand that this is a negotiated plea of guilty, which means the state will recommend the sentence to the court of the 10 years probation, the family violence intervention program, and no contact with Ms. Murray, the victim in the case. But the court does not have to accept this recommendation. The court can sentence you to the maximum on this charge. Do you understand that?
Yes, ma'am.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well in other jurisdictions, including federal court?
Yes, ma'am.
You understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a plea of guilty?
Yes, ma'am.
You understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
And if you do further violate any criminal laws, you could be subject to revocation.
Yes, ma'am.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
You understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at a trial would. And that is true regardless of any advice by your attorney.
Yes, ma'am.
You understand that neither the court, nor the attorney, nor your attorney, nor the district attorney has anything to do with parole, the Department of Corrections and Parole, and no one can guarantee parole no matter what.
Right, exactly. Yes, ma'am.
And do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just like there would be a conviction following a trial? For example, your guilty plea conviction may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
And do you understand that by pleading guilty to a felony, if you use, possess, or transport a firearm, or use a firearm, you'll be guilty of a felony, which may carry a sentence to 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up the following rights? I'm going to list them: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called against you, the right to assistance of counsel hired by you, appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt, and finally, the right to appeal if convicted of these charges after trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to enter this plea of guilty?
No, ma'am.
Is your decision, excuse me for one moment. How do you plead to the charge of aggravated battery in indictment number 18 SC 163444?
Guilty on the offer versus North Carolina.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, ma'am.
Is this guilty plea freely and voluntarily given, this guilty plea under Alford, freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal? You
Yes, ma'am.
understand that you have 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea under Alford?
Yes, ma'am.
Your Honor, regarding Mr. McCarver's criminal history, he has 9 felony convictions ranging from 1989 to 2012. He has no further convictions after 2012. Would you like me to list them?
I would not unless you're aware of any that involve violence against Ms. Murray.
No.
Okay. Thank you. And you're not, I'll ask Ms. Crawford to confirm, but there's nothing that's open and active as far as you know?
I believe he's still on probation for a drug case
Yeah.
from 2011. He was sentenced to 20 years probation for possession of cocaine.
Okay, do you have that case number?
I do.
Because we may want to wrap that up so that this doesn't sneak up on Mr. McCarver.
So there are 2 cases that he's still on probation for. They're lengthy probation sentences. The first case is 11 SC 99747, possession of cocaine. And the second case is 11 SC 104201. That's a burglary case from 2011.
Okay.
As to the allegations in this case, if this case would have proceeded to trial, the state would have expected its evidence to show that on November 15th, 2018, Officer Gallen was dispatched to Atlanta Medical Hospital in reference to a person that had been assaulted. Upon arrival to the hospital, Officer Gallen spoke to Ms. Lakia, L-A-K-E-I-A Murray, M-U-R-R-A-Y, who stated that on November 14th of 2018 at 1704 Madrona, M-A-D-R-O-N-A Street in Fulton County, her and Mr. McCarver got into a verbal dispute regarding Ms. Murray's potential infidelity. Ms. Murray then told officers that Mr. McCarver took a bed railing or some kind of pole and repeatedly hit her with it about the body. Ms. Murray, and pursuant to the medical records, suffered a fracture to her ankle. Ms. Murray is 52 years old, Your Honor. I have personally been in contact with Ms. Murray, and she really does not want contact with Mr. McCarver. She is okay with the resolution in this case. She does not want to make a statement in this case. And that's the recommendation of the state.
Got it. Thank you. Ms. Crawford, do you agree with what I heard from Ms. Beza in terms of open probation cases?
That's correct, Judge McBurney. He does have 2 open cases. The first case, the 11 SC 99747, he has 19 years, 5 months, and 12 days remaining. The second case, 11 SC 104201, he has 9 years, 11 months, and 13 days remaining.
Okay, thank you for sharing that.
You're welcome.
Mr. Webb?
Thank you, Your Honor. First of all, I would ask the court to accept the plea. I think it is a reasonable resolution, particularly under Alford versus North Carolina. Mr. McCarver had indicated to me his concern that this plea might result in the revocation of his probation. And as I advised him, I can't guarantee that, but I would think that at this point in time, that if a petition was going to be filed, it would have been filed based on his arrest in this case. And the
We'll
charges-
fix it today so that that doesn't end up happening.
Oh, good. That was what I wanted to do to protect my client. And the only other thing I might observe, Your Honor, I don't want you to think I'm hung up on aggravated battery today, but she mentioned that it was a fracture to the ankle. I don't know if that qualifies as a permanent disfigurement. Maybe we should plead under, is there an ag assault count in here too?
I can go further with her injuries as of today. She still is having ankle problems and is able to walk correctly. She still has pain to the ankle and she still seeks treatment as of today, which is 3 or 4 years later.
Oh, okay. Well,
and this is not pled as serious disfigurement. It's pled as depriving. I assume it means use of it. Actually, the way it's written, she lost her ankle as it was removed. I assume that what the showing would be is that it's deprived her of the meaningful use of her left ankle, which is supported by what Ms. Beza just said about continual hobbling, et cetera.
I'll certainly stipulate to that, Your Honor.
Okay.
And I wasn't questioning Ms. Beza's credibility at all. I just am trying to be careful with my clients when I represent them as to.
Care is good, and no one felt like you were questioning. I didn't feel like you were questioning Ms. Beza. This one is pled differently. It's not a disfigurement.
Okay.
It's a loss of use. All right, Mr. McCarver. First, before I get to you, Mr. Webb, do you waive any issues arising from the fact that we're working off a copy of the indictment?
I do, Your Honor. I waive it.
Great. Mr. McCarver, you picked up a bunch of cases way back when, and they sound like they were cases that maybe were a byproduct of you working through an addiction.
Yes.
Is that a fair statement?
Yes, sir. That's what it was.
Have you gotten treatment, or did you just?
I'm done with it. I'm done with it. I haven't broken the law since 2011, 12, something like that.
How did you achieve sobriety? Did you go through a program, or?
Yes, sir.
What was the program?
It's a 12-step program I went through.
Okay.
In East Point.
And it helped?
Yes, sir, it did.
Good for you.
Mm-hmm. And I haven't done since like 2011, 12, something like that. And I haven't broken the law since 2011, 12.
You worked
I've been on my job 20 years.
What's your job?
I'm an appliance technician. I worked for SEAL for 15 years. So they went out of business. Then I
Okay.
got,
Do you have your own shop where you do appliance work, or
No,
do
I
you work for some?
more than all things furniture and appliance. I worked there. He got 4 stores, and I run the whole 4 stores.
Okay.
Yes, sir.
Can you say the name of the place again?
All things furniture and appliances, right there on the corner, more drive.
Got it.
Yes,
Okay.
sir.
So, Mr. McCarver, you're entering this plea pursuant to North Carolina versus Alford,
Yes, sir.
which is a case that allows a judge like me to accept a plea when a defendant says, Judge, I don't agree with what the state said happened. I know, Ms. Murray, we had an argument, but I didn't break her ankle with a pole. But Judge, I still want to work this case out. I don't want to go to trial and run the risk that a jury hears about my criminal history and they say, throw the book at McCarver.
I went and got a warrant. I had to put out my house. That's what it's called. Yeah. I got a warrant. I went to the sheriff's department, got a warrant. Yeah.
Okay, but you are interested in resolving the case because you think the plea is in your best interest.
Yes, I have one problem. That program I have to go through.
Yeah, the program you have to go through.
Yeah, I work like 12 more hours a day. Look at mine.
Okay.
And when it's gonna have, I won't have Sundays off. I work to keep myself going and keep my mind straight. So I just work all the time now.
Okay.
You know, keep me out of anything. You know,
I hear you, and it keeps you going straight. Let me get back to my question though. Are you entering this plea, Mr. McCarver, even though you disagree with what the state said the case is about, because you think it's in your best interest to work the case out?
It's been over 3 years. I just want to get over with.
Okay.
Yeah.
Well, Mr. McCarver, I find there's a factual basis for the plea. If Ms. Murray came in here and said what she said happened and there was the medical evidence, a jury could believe her. I don't know that they would. You don't know if they would either, which is why you don't want to run that risk. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we've been talking about. Is that true?
Yes, sir.
Okay. And voluntary just means, even though you're not excited about this, you've decided on your own, with advice of your attorney, that this makes the most sense for you. Is that correct?
Yes, sir.
Then I'll accept your plea. I'm sentencing you under the Probation Options Management Act, which means, Mr. McCarver, that while you're on probation, if you have a technical violation, you miss a meeting or something like that, you and probation will work that out.
Yes, sir.
If it's something more serious, you get arrested again, which you say hasn't happened for a whole bunch of years. But if that does happen, that comes back to me.
Yes, sir.
Okay. How did you know Ms. Murray?
Well, I met her, I didn't too long, no, I know about 2 years before that happened.
Okay, had you guys been talking with each other?
I know, we both of us was on drugs. You know what I'm saying? That's how I really met her.
Okay.
You know what I'm saying? Yeah, I got myself clean, but she was still out there.
Okay. When was the last time you saw Ms. Murray?
It's been some years now.
Okay.
Yeah.
You understand you're gonna need to stay away from her as part of this sentence.
I don't want to, yeah.
Oh, good. But and she wants the same thing. She doesn't want to see you. So if you know places she hangs out, you can't go around there.
Exactly.
If you're walking down the street and you see her coming, you have to turn around and walk away. You understand?
Mm-hmm.
Okay. I'm not kidding around. I just want to make sure you know, because if she snaps a picture of you, look, here's Mr. McCarver around, there's trouble for you. So you're going to want to stay away.
Yes, sir.
All right. Mr. McCarver, I'm going to sentence you to 5 years probation. And it will be a special condition of your probation that you have no contact with Ms. Murray.
Yes,
No
sir.
direct contact, no indirect contact. You stay away from her. So that's 5 years. She knows she don't have to worry about you. By then, you're going to be 60 years old.
Yeah.
You're done doing crazy stuff by then. You're done now. You better be done now, because jail's going to break you.
Exactly.
All right. Because of this conviction, I'm going to revoke 6 months of your probation in 11 SC 99747.
Okay.
Hold on. And 6 months of your probation in 11 SC 104201. I'm going to reduce that to time you've already served. And I am going to suspend the balance in both those cases.
Thank you.
So those cases are now gone. But you got 5 years that you got to keep your nose clean and your hands off someone like Ms. Murray, or at least poles off her. And then, like I said, you're going to be about 60 years old. And my hope is we've seen the last of Mr. McCarver here. I'd love to see you in the appliance shop, but not in a courtroom.
Thank you.
That's how we're going to handle this. Mr. McCarver, do you authorize me to sign the indictment on your behalf?
Yes, sir.
Mr. Webb?
Yes, Your Honor.
And Ms. Beza?
Yes, sir.
All right. Ms. Crawford, do you need anything more from me? I got to go take this call. I know you need some information from Mr. McCarver. Do you need anything from me?
Nothing from you, Judge.
Okay, great. And I think you're all set. Yes, ma'am. Thank you.
Thank you, because you've been hanging on my head a long time.
Hey, not a problem. You just get this right. You just keep working 6 days a week and you found yourself a good routine and you keep it up, okay?
Yes.
All right. Now, Ms. Crawford needs to ask you a few questions about address and whatnot. She's going to give you reporting instructions. Mr.
Yeah.
Webb's going to write it down. And it may be because you're already on probation, it's simpler, but
Okay.
just please listen to her, okay?
Yes, man.
All right.
Yes, sir.
I want to give you an update. I want to put it on record I want to be done with the server issues that we have in this case. So I provided Mr. Webb with a 911 call and Mr. Bailey, they didn't have.
Mr. McCall.
Yes, ma'am.
From probation.
Only other thing he is missing, which.
Can you hear me?
Let's go this way so we're not
Ma'am.
talking over Ms. Crawford. I'll see you at, you don't need to take this part down.
Ma'am.
I just need to see, do you still live at 365 Elatuna Place in Atlanta, Georgia?
Yes, ma'am.
Okay. I'm gonna give you a reporting date. You're gonna report to the same office, but you're gonna
Oh.
report to Officer Hayes on
Yes.
October 6th. October
Okay.
6th at 11 a.m.
Yes, ma'am.
That address is 276 Memorial Drive Southwest.
Yes, I know where it's at.
You know where it is? Okay.
Yes, ma'am.
I can give you my telephone number. Give you Officer Hayes' telephone number if you have any questions.
Okay. Give me her number again too, yeah.
Okay. So Miss Officer Hayes is 404-227-2000. And then my telephone number, I'm Miss Crawford. My number is 470-303-6860.
Got it.
Okay, so your other two cases will be closed and you just have that one case open, okay?
Yes, Miss Crawford. Thank you.
All right, thank you.
Yes, sir.
Report October the 6th. 11:38.
My head long time.
You got a great deal, say.
You've been hanging on my head long time. I just want to over it, you know.
Well, it's,
Yeah.
you're in good shape now, okay?
Yeah.
All right, God bless you.
Thank you.
You're welcome.
Thank you, man. Real good.
Mr. Webb?
Yeah.
You said you've been around.
We don't have nobody else to watch. And take 2 months to get down to bed.
Yeah. No, I wasn't doing much work here back then. In fact, I just came from the Cowboys.
Oh, you're in the So you know, what is it?
But it is, it's overkill. I don't know. Who's it?
It's
From Jackson, maybe, or somebody.
I says it in the system. I never just closed my computer. I don't remember. They just. McBurney split my thing in half.
He sure did. He don't like a lot of probation. I could.
He doesn't?
Well,
But because it's a battery, add battery. I
He
think
just still feels like if he's gonna get in trouble again,
he would have done it within 2 years. I mean, that makes sense.
see, I had a little trouble. He was really nice. So.
I knew we weren't gonna file anything.
I didn't
We would
think
have done it
so.
already, but
Yeah.
like the judge actually just closed it. He was like, I'm not dealing with this. Wow.
That was
Which
great.
makes sense. 19 possession of
I didn't see
cocaine
that
with
coming.
11 SC. Is that a joke?
Back
19 years.
That and burglary, people used to get. It
I
comes
can
back.
see if it's a shooting,
Mm-mm.
but having
one.
a bag of cocaine in your pocket, you get 19
I had one that
years.
was 17. He had gotten 25 years. He got whatever to serve, like 5, and then he got.
5 years in jail for drugs.
Mhm.
I can't.
Maybe it
I
was
cannot.
because he had 9 prior felonies.
It don't
maybe
matter
because
what.
of his
I don't
prior
think he had
record.
100 prior felonies. I think
No.
it's crazy.
Somebody, whoever was really punitive
Yeah,
on
I
that
don't
one.
know what the judge that was. That's-
Yeah.
See you guys later.
Bye.
Okay. Bye, thank you, Asia.
You gonna be in here first?
Yeah, I'm gonna be here.
Okay, I'm just going downstairs to grab something for the record. Are you, did you see that video?
Yeah, he saw it. I saw it.
Okay, all right.
Ms. Hall,
I'm sorry, Deidre, is that you?
no, it was Ms. Crawford. I was trying to get Ms. Hall. I'll contact her via phone. Thank you.
Okay, all right.
I got, I still got a person in custody with me in 8 days, so I'm just standing by with him. I just told Talton to go ahead and give him something to eat. And then whenever you get somebody available, come relieve me. No, it's 82. He's coming back up at 1:30. So I just told, so I just told Talton to go ahead and eat. You see what I mean? 'Cause we can't get anything up here unattended. Because HC is down, you know what I'm saying? So I'm up here with the 82. So whenever you get somebody available, then I go to lunch. And then the attorney, he's still up here too in the courtroom. You're gonna take, because you're taking a plea. You're supposed to take a plea. Yeah, that'd be fine. And then you can, have this person leave. How do you want to do it? Believe me, or 27 in 5. Okay, I appreciate it. Come on.
Is Broughton still back there?
Yeah.
Can I talk to him?
Yeah. Sure. Yeah.
That's hard. So when you judge supposed to come back from the bench? In 15 minutes? Okay. So he just got that one inmate to take care of. Okay, so y'all be done.
Well, no, you gotta, they got another plea, somebody that's doing a child molestation case over the week. So after, you got them coming after.
So he
this
only
after
got
this.
one.
Mhm.
Okay,
Yeah.
all right.
It'll be just a few minutes before the judge comes back on the. Okay.
Yeah. So it's gonna take a while because he's Hispanic. You're gonna have an interpreter and all that.
Okay.
Mm-hmm.
So I was gonna say, well, Wiltshire, because love with that, trial down there, they got 3 key separates.
Okay.
So right now.
Oh, so you need wheelchair down there?
Yeah, right now I got. Wiltshire
Okay,
down
well,
there.
I mean, whenever you, I mean, if it's later, that's fine.
Okay.
Yeah, if you need her down there, that's fine.
Okay, so it's like, it's somebody else.
Yeah, next person to come out or something.
Okay.
That's fine. All right.
Saying what I want to say. No, I'll ask the judge if you can. Yeah, I can't stop him from, okay? Okay. All right.
Still speak to him too, Mr. Will.
I will.
No, he gonna be back. I mean, we got one more case. We can do it on the motion. You want what? Oh. Hold on. Hold on. Okay. Yeah, go back. Hold on, I'm yes.
Hey there.
Talk to your guy.
Yeah, we're all set. He just wants to run his.
Most definitely. Give me 2 seconds. Is he back there, sir?
Yeah, somebody's back there with him.
Right.
Thank you.
Got that other guy, he's supposed to be taking a plea, the one that's on bond.
Who is that?
Hispanic man, he's Hispanic, remember the one that had an interpreter?
I didn't know he was on the calendar today.
Yeah, they said.
What's his name?
Talk to immigration.
Oh, that's not my client. Oh, y'all have that.
Yeah.
Oh, I thought you meant me.
He said he had to talk to immigration attorney.
Yeah.
He was supposed to see what time.
Yeah.
So
That'll be
may be today, because he said he got something at 3:00,
Yeah.
something at 3. So you're gonna see if that one need to be done before 3 or something. I don't know.
Yeah. We're ready to go on this one on Broughton and ready to go ahead and plead him and close that out. I wish I still had a cafeteria here in the courthouse that was open.
They need one, but they're not gonna spend the money. In order to get the cafeteria like they got at the sloppy Floyd, or they got to spend $1 million.
I didn't know the one at Sloppy Floyd is open.
I don't know if it's open now.
I go to the one at 244 Washington.
It's just like, I don't understand it.
Yeah.
How come they don't have a cafeteria to serve hot food? Do you ever notice that? I don't know, cafeteria to serve hot food. With all these buildings connected, all these employees and people in this building. And you don't have no place for people to eat no hot lunch.
I know.
You gotta go outside. Don't know other place down there have to go outside?
Well, they don't have one in the
City don't have the city hall, they ain't gotta go outside. The federal building, they don't have to go outside.
I don't think the city hall one is open, is it?
No, it's not open.
Yeah.
But I'm just saying.
They don't, yeah, I know what you're
I
saying.
mean, you could,
Well, I know,
This is the time where you should be trying to put something together.
I
So
know.
that when it does go fully, it's gonna come back full sometime next year, probably.
I agree with you. I
It's
agree
gonna
with
get
you.
back to normal sometime.
Yeah. I am a little worried though, other viruses like the flu pandemic in the early 1900s, the plague and all that, they eventually got
I'm
weak.
like, this, you know how, but see, this is people dying. You mean stuff that I like, what you think is not real or something? That's what got me.
I know those viruses got weaker, but this one keeps getting stronger, it seems like. I can't help but wonder if there's not a biological weapon.
I seen on the thing, they said they was planning to, whatever that is, that virus, they was planning on giving it to, like, some rat, like, putting it, like, trying to give it to, like, bats.
Yeah.
And the bats is gonna have the virus, and they gonna give it to the bats. That's what the plan was, but, corporate order. That's all right.
Thank you all for being back.
No problem. I never left.
All right. Thank you for being here.
I never left these guys, I didn't leave.
Well, all I did was step across the hallway and get on a call, so we all stayed. Mr. Webb, we ready for Mr. Broughton?
We are, Your Honor.
Great. And we'll get on the record what he wants to do.
Sure.
Ms. Hall, would you be able to be ready for Mr. Broughton next Tuesday or no? Oh, you're gone next week, aren't you? Okay, never mind. Better be going somewhere good.
Well, I want to announce, so.
Oh, I'm sorry.
Thank you.
All right, let's get on the record in Mr. Broughton's case. It's position 7 on our trial calendar, 17 SC 150777. Mr. Broughton, thanks for bearing with us. We were on the record earlier today talking about what the state's offer was. They were going to recommend 10 years to serve 7 years. You were explaining to me you're not interested in that. You were explaining why. What's been going on in your life, et cetera. Then you and Mr. Webb began talking about a non-negotiated plea. And then we had to take a break because I needed to fit in one other plea and excuse a couple folks before I had a conference call I had to be on. Excuse me, that's taken care of and we're back. And I want to take your pulse again, figuratively speaking. I got the sense before you left the courtroom that you were thinking about exploring a non-negotiated plea, which simply means the state's going to recommend what you heard, and Mr. Webb is going to recommend something that you and he have talked about that presumably is less than 10 to serve 7. And then I'll listen to both sides and I'll let you know what's going to happen. But importantly, whatever sentence you get, it's one where you are parole eligible, which would not be the case if you went to trial and you were found guilty. So that's what we talked about before. Tell me where you are now. Are you interested in doing the non-negotiated plea?
Yes, sir.
Okay, well then we're going to do that. I'm going to have the two of you go to the podium if that's all right, because it's a lot easier for Ms. Rivers to hear you if you're near that microphone there.
Yes, sir.
And Ms. Hall, you can go to witness stand or your table, either way. So, Mr. Broughton, in just a moment, Ms. Hall's going to put you under oath. Once you're under oath, you need to answer all of her questions and mine. We'll both have questions. She'll have more, truthfully and completely. And I need to answer any questions you have, but I won't know you have any questions unless you stop us because someone says something you don't understand, or they say something that's just going differently from what you and Mr. Webb talked about. If all of a sudden they're saying, yeah, and you're charged with child molestation, you just, wait a minute, what? That's not what this case is about. I will address your question as best I can, or if you and Mr. Webb need to speak privately, we'll get you back there so you can speak privately. But you need to let me know that you've got that need, okay?
Yes, sir.
And we will accommodate it. All right, sounds like we've got a plan. Ms. Hall, when you're ready.
Thank you, Your Honor. Ms. Bryant, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Julius Eugene Broughton.
And are you also known as Emmett Smith?
Yes, it's an alias name that I use.
And is that something, I usually won't interrupt, but did you just have some other case where you said your name was Emmett Smith, or was it this case where you told someone?
It was another case.
Okay, and so that alias just follows you around?
No, sir. Actually, it was a case that I got arrested for in 2020, April 4th, 2020, for an aggravated battery case.
Okay, and that's the name you used when you got arrested?
No, it didn't name to use. That's the name the police assumed that my name was because I told them that was my name previously. I got pulled over. That's my homeboy name. I used his name because he got licensed, and they assumed that I'm the same person.
They recognized you?
Yes, sir.
Got it. They said, there's Emmett.
Yes.
Okay,
Yes, that's
got
what
it.
was.
So you've used that name maybe in a traffic encounter at some point?
Just
because-
one time because I didn't have no license.
Okay, understood. But Julius Broughton is your legal official name?
Yes, sir.
Thank you.
Yes, sir.
Ms.
You're
Bryant,
welcome.
oh, I'm sorry.
No, I just say you're welcome.
Ms. Bryant, are you taking or under the influence of alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 39, ma'am, and I got my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with aggravated assault with a deadly weapon, possession of a Schedule 4 controlled substance, willful obstruction of a law enforcement officer, aggravated assault, possession of marijuana less than 1 ounce, and drugs not in original container?
Yes, ma'am.
Do you understand, excuse me, that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Webb, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I did. I
Do
spoke.
you need more time to discuss this case with your attorney?
No, ma'am. We just spoke out there, so I mean, not right now, not at this time, no.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
Do you waive moving forward on a copy of the indictment?
We do.
Mr. Broughton, have you been arrested on these charges?
Yes, ma'am. I got a risk.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
It's not, ma'am. No, ma'am.
No, we're not aware of any.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
For the aggravated assault with a deadly weapon and aggravated assault are both 1 to 20 years to serve. On all 3 misdemeanors, the willful obstruction of a law enforcement officer, possession of marijuana less than 1 ounce, and drugs not in original container are all misdemeanors, which the maximum will be 12 months to serve.
Yes, ma'am.
And then for the possession of a Schedule 4 controlled substance is 1 to 3 years to serve.
Yes, ma'am.
You understand? Do you understand this plea may be used to enhance sentences on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind? I'm sorry, your probation. I'm sorry, if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today.
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that your guilty plea, also called a non-negotiated plea, I apologize. Do you understand that your guilty plea, also known as non-negotiated plea, something's going on with my head right now. I apologize.
Yes, ma'am.
Your guilty plea is also known as a non-negotiated plea, and the state will still make a recommendation to the court.
Yes, ma'am.
Sorry.
It's
Do you
okay.
know what the state's offer is, or are you aware of the state's offer?
Yes, ma'am.
I will repeat it and put it on the record at this time. Aggravated for the counts of aggravated assault with a deadly weapon, and just aggravated assault will be from the state's. The recommendation will be 10 years to serve 7 years balanced on probation. Credit for time served. The possession of a Schedule 4 controlled substance will be 3 years to serve. And all 3 misdemeanors: willful obstruction of a law enforcement officer, possession of marijuana less than 1 ounce, and drugs not in the original container, be on 12 months probation. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
An indictment number
17
Thank you.
SC 150777.
How do you plead to the charges of aggravated assault with a deadly weapon, aggravated assault, possession of a Schedule 4 controlled substance, willful obstruction of a law enforcement officer, possession of marijuana less than 1 ounce, and drugs not in original container?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am, with the non-negotiable plea. Yes. Yes, ma'am.
Do you understand that you only have a limited right, which is 30 days to appeal this guilty plea?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the defendant, the state is aware of 9 prior convictions by the defendant, leading all the way back to 2000. And the most recent conviction should be a robbery charge out of Fulton County.
Bribery?
Robbery.
Oh,
Sorry,
robbery. Okay, like never heard of anyone bribery in state court. All right.
It's the mess.
All right.
That disposition was April the 27th of 2007. The defendant does currently have an open case in our office. It is a CP case.
Oh, open, not meaning he's on probation. He has an open unindicted case.
Yes, Your Honor.
What's that number?
I left my calendar over there, sorry. It is
What are the charges?
aggravated battery and aggravated assault. Thank you.
Okay.
It's 20 CP 191047.
Thank you, Ms. Nelson.
Thank you.
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven that or expected the evidence to show that on October the 13th, 2016, at 3/8 43 Jonesboro Road, Southeast Atlanta, Georgia. That's in Fulton County. Officers received a call that a man was stabbed. Our victim, Mr. Thomas McDaniel, was taken to the hospital. At that time, they didn't have the suspect. They received an anonymous call later that the person who stabbed our victim was back at that same store. That is a gas station where this happened at. Officers arrived and encountered the defendant. The defendant matched the description that the caller gave as being the person who stabbed Mr. McDaniel. When they went to approach the defendant tried to flee, but they were able to apprehend him. The victim, search incident to arrest. Your Honor, the defendant was found with less than an ounce of marijuana on his person and one Xanax pill. The officers did do an investigation. They pulled the surveillance camera footage from that gas station, which showed the incident. It showed the defendant and the victim having a dispute, an argument. Well, to be specific, it shows the victim walking up behind the gas station. He told me that he was using the restroom. You can tell he's standing in the video with his back turned to the public. The defendant walks up behind him, snatches his phone.
When you say using the restroom, as in relieving himself, but he's not in a restroom.
Correct.
There's a space and he's taking advantage of that space. Okay.
Right next to the dumpster. And the defendant walks up to him, takes his phone out of his back pocket, which alerts the victim. He turns around, snatches his phone out of the defendant's hand. The two begin in their surveillance to have a dispute, arguing back and forth. The defendant then pulls a knife out of his right jacket pocket and he starts to point it and swing it at the victim. At some point, he got close enough to the victim to where he stabbed him in his left chest. The victim falls, and even when he gets up, looks like the defendant is trying to go at him again with this knife, but the victim runs off. And then at that point, both individuals leave out of the camera footage. The victim have since recovered from his injuries. I've spoken with him. He is very interested in prosecuting this case. He's homeless and he hung out at that store along with the defendant. And his understanding of what happened was that he was just misidentified by someone else that was at the store as to being the person that maybe took the defendant's property overnight while they all were at the store. That is all from the state, Your Honor.
Okay. Let me look at one thing. Okay. So the unindicted case involves Mr. Broughton, they use the name Emmett Smith in it, purportedly breaking some guy's nose with his fist. Just allegations, but I wanted to make sure, one, it wasn't Mr. McDaniel, and I was curious if the allegation involved a knife or not. This sounds like it was a punch to the nose. But that's not why we're here. It's just that's an open case that Mr. Broughton's going to need to deal with anyway, although this resolution may affect how that plays out. Ms. Crawford, does Mr. Broughton have any cases for which he is actively on probation?
Judge, Mr. Broughton has one case that's open and active, but it is in Clayton County. It's not in Fulton. So there's one open case in Clayton County.
What are the charges in that case?
The charges are possession of cocaine, theft by taking, and simple battery.
How much time remains?
Let's see, that case ends January 13th of 2023. Give me one moment. It's about two years. Hold on.
That's fine. I can do close enough math. Thank you.
You're welcome.
All right. Mr. Webb, tell me what you want to share about Mr. Broughton and this case, please.
Yes, Your Honor. Thank you. First off, this is a 2016 incident that was indicted in 2017. Mr. Broughton has spent, well, as of the date the calendar was published, he had spent 510 days in jail.
All of which he'll get credit for.
Yes, sir.
Day for day.
Day for day. I watched the video of the incident with my client this morning in court, thanks to Ms. Hall furnishing her laptop to me.
That's why the laptop was over there. Okay,
Yes.
thank you.
I tried to play it last night and I couldn't get it to play on my own home computer.
Something about computers operated by someone named Webb. Nothing she provides works.
That's right, Your Honor.
Your ghost dad too. Okay.
Mr. Broughton has, I understand he has a previous record, but I'm asking the court to sentence him to 10 years with time served. And part of the reason for that, Your Honor, is I think that 510 days in and out of the Fulton County and Clayton County jails, a large portion of that being during a pandemic with COVID-19, is probably worth double the punishment in a sense. He has indicated to me remorse. He accepts responsibility that he made a mistake. And in looking at the video, I don't know what happened before the figures entered the video. I did see a fight between them and some pushing back and forth, and it did show that he had a knife. And I don't think that the victim didn't have a knife, and that I'm not trying to apologize or excuse that, but it does look like there was an angry exchange between the two of them, Your Honor. And so I'm requesting the court impose a sentence as I related or requested of 10 with credit for time served. Now, I think Mr. Broughton would like to address the court. I told him that if I tell you that he's remorseful, that really doesn't mean much. I think it's better.
It means more than nothing. That's for sure.
Well, yes, sir. Yes, sir. But I think the words coming from my client rather than me, you hear defense attorneys day in and day out that tell you that their client was in the wrong place at the wrong time and they
didn't mean it,
and they've turned their life around. And I would like you to hear from him because I think you can judge the sincerity of his position better.
Okay, I'll hear from him in a second. I have a question for the two lawyers. I'm not quite sure that counts 1 and 2 should stand individually. I should say that better. I think they merge. They are charged slightly differently. Count 1 is the actual stabbing. Count 2 is the swinging the knife at. And so I was waiting to hear, actually, Mr. Broughton was swinging the knife and then the victim went away and was scared and told someone he was scared. And then 10 minutes later, Mr. Broughton was stabbing. But it sounds like from any view of the encounter as memorialized in the video, they're swinging with one swing ultimately making contact. And so I think it's not going to change much other than it's one fewer count for Mr. Broughton, that 1 and 2 ought to merge. Your thoughts on that, Ms. Hall?
I agree, Your Honor.
I agree, Your Honor.
All right. You're on a roll with the mergers, Mr. Webb. All right. So Mr. Webb has shared with me his perspective. Mr. Broughton, anything you want to tell me?
Yes, sir. It's like I told Mr. Webb when he just came out there to speak with me, and I was just talking about the non-negotiable plea, asking will he speak with you about going down on the time, because I got arrested on the case in Clayton County. I did 13 months, and I still had to come over here for this same particular case, even though I got out of jail. But before all this, after all this happened in 2016, like I was saying earlier, I had a daughter, and my life, I don't even live the same way. I don't even think the same. I don't even move the same way. Like,
well, you do have this new, I'm sorry to interrupt you, but, and I don't want you to talk about the new case,
Yes,
but
sir.
I'm hearing your words, and then I'm looking at this case you picked up where allegedly you busted some dude's nose. And you don't have to justify that, but that doesn't sound like it's consistent with you not walking that way anymore. Just airing that out there, but you keep going.
Okay, and I can explain to you about that since you
don't, because that's an open case and you may say something now and then the prosecutor's like, he said he didn't mean to, but he did break the nose. So let's keep moving on.
Yes, sir. I didn't break his nose, but yes, sir. But like I ended up back out there in the street because of me and her mom broke up, and she just pushed me to the street, pushed me away from my daughter. That's how I ended back up out in the street. I really had been doing good, like for about a year and a half after I got out of Clayton County Jail with the probation and everything. And it just went AWOL. And like you just said, it'll look like that, like I wasn't, but I was. And I'm not the same person, Judge. And I just ask that you just feel my pain in my heart. Like I'm not even the same person. I'm sorry. I mean it to the court. It's not to cut you off, sir.
Nope, you didn't cut me off. It was your turn to talk. So your Clayton case was the drug case.
Yes, sir.
And you said you served, how long were you in Clayton County Jail?
From February 14, from February, I don't know the exact date, but to March, I got released like March the 22nd or the 23rd. It was
So
like
a year later.
13 months.
Okay.
Yes, sir.
And let me make sure I understand the timeline. This situation with Mr. McDaniel is in October of 2016.
Yes, sir.
And you got arrested. Did you get a bond or did you not get arrested right away?
I actually I didn't get arrested right away, but when they did pick me up for it, I got arrested and Judge Down did give me a bond. I got a bond.
And you got out and then picked up the Clayton charge?
I got out in 2016. Yes, I got out like 3 weeks later. And then I was out of trouble, whatever, until 2018.
So Clayton was 2018?
Yes, sir.
And you did 13 months in 2018?
Yes, sir.
All right. And then you went from Clayton to here on these charges?
Yes, sir. Yeah, I got
Or did you get out?
I got out in 2019.
Okay.
And
So
then
why have you been in jail for 510 days in Fulton? Why did you get picked back up?
On the aggravated battery, the one with the dude.
Oh, the broken nose guy.
Yes, sir. In 20,
That is what you've been in since then.
In 2020, yes, April the 4th, 2020.
Okay. So you've done, since Mr. McDaniel got stabbed, you've been in jail 2 different times.
Yes, sir.
One was a little over a year in connection with the Clayton charges.
Yes, sir.
And then more recently, you've been in for, we'll call it a year and a half.
Right at 18 months. October the 4th will be 18 months.
Year and a half. So that is in connection with the broken nose guy, but that may have affected your bond in this case as well.
Yes, sir. Maybe.
Okay. So a little less than 2 years already.
Yes, sir.
Understood. Okay. All right. So, Mr. Broughton, I do find there's a factual basis for your plea. It sounds like Mr. McDaniel's testimony and video footage that I can't imagine the jury would not see in your trial would show what happened. And so a jury could very readily decide, this guy stabbed the other guy. And maybe there was some pushing and shoving, but I'm confident Mr. Webb would argue self-defense and justification. I don't know how that would play with the jury. And so I find that a jury could find you guilty based on what I've heard. I also find that your plea is knowing and voluntary. Voluntary means that you are entering this plea because you understand what's going on, and understanding all that, you think it's the right thing for you to do. Is that correct?
Yes, sir.
No one's forced you to enter the plea?
No, sir.
All right. And a knowing plea is simply one where the defendant understands what's going on, understands the rights he's waiving, the consequences of the plea, what the recommendation is, et cetera. You feel like you understand what we're doing?
Yes, sir, I do.
All right. Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means for the part of your sentence that's probated, if you have technical violations, you and probation will deal with that. If you miss a meeting, you test positive only a few times for something, then you and probation sort that out. But if it's anything more serious, you catch new charges, that revocation comes back to me.
Yes, sir.
So, Mr. Broughton, I hope that you are prepared to chart the new course that you say you are because your daughter, et cetera. It sounds like there's still some rough patches for you. You and your daughter's mom got into something and she kicked you out, and then you were on the street again, which is a bad place for you to be. Picked up these new charges where someone's nose got broken, and you still have to work through that. You've got Clayton County that is going to want to maybe visit with you after we sort this out. You've got a pretty messy criminal history. And so I can't ignore the past, but I certainly also want to pay attention to your future, which you are telling me is going to be a different thing. I hope that's the case. But this case, I'm now not talking about a broken nose or cocaine in Clayton County. This case, I don't know how many inches you came from this being a murder. Not because you meant to kill someone. You don't have to mean to kill. But if that knife goes into Mr. McDaniel's side and it pokes the wrong thing, he flops down and bleeds out. At a minimum, felony murder. Because you stabbed him. I didn't mean to kill him, but he died as a result of the stabbing. We're not talking about 7 years or 3 years. Your daughter will visit you when she's old enough and watch you die in prison. So you need to be thoughtful about how some of this stuff can play out when you're working through it. I need you to be thoughtful. I need there not to be another Mr. McDaniel. You lose your cool about something, you need to handle it in a different way.
Yes, sir.
So there are consequences for that. I think that a reasonable sentence in this case is a sentence of 10 years to serve 5 years with a balance on probation. I will ask Ms. Nelson to ensure that your sentencing sheet show that you get credit for the time in Clayton County as well as the time here. You were not sentenced in Clayton County in connection with this case, but the deterrent effect of you being in jail is just as powerful back then. And I think it's part of this sentence. If I am told that you cannot get credit for that, I will modify your sentence. No problem. It's all right. If I am told by the Department of Corrections or the sheriff that I can't give you credit for the Clayton time, then I'm going to shave a year off the sentence. And so then it becomes 9 years to serve 4 years. If I can get you credit for that, then it's 10 serve 5. So it's 5 years probation, 5 years in custody for coming close to killing someone. I don't think the state's recommendation is an unreasonable one. The reason why I'm coming down a little bit is so much time has passed. That's not your fault. It's not Ms. Hall's fault. But after a while, saying you're a bad guy for something you did 5 years ago, that's a little late coming in. But you've been serving, and you'll get credit for a bunch of time in connection with, in my mind, in connection in part with what happened to Mr. McDaniel. I don't recall you asking for any special conditions, Ms. Hall, but I assume one of them is no contact with Mr. McDaniel. Was there anything else?
Stay away from the location.
Okay, the gas station on Jonesboro. What was the street address? You can look that up while let me pronounce sentence on the rest of the counts. So your sentence on count one, hear all this out because you'll need to talk to Mr. Webb afterwards. Count one is the 10 years to serve 5 years, credit for time served, balance probated. Count two, I think, merges into count one, so it goes away. Sentence on count three is 3 years to serve, but that runs concurrently at the same time with count one. And counts 4, 5, and 6, all misdemeanors, are 12 months to serve, and they all run concurrently with count one as well. So again, the overall sentence is 10 years to serve 5 years with the balance probated. No contact with Mr. McDaniel, special condition number 1, and special condition number 2 is to stay away from the gas station at
3843 Jonesboro Road, Southeast Atlanta, Georgia. I don't have the zip code.
It's all right. We can look it up, but 3843 Jonesboro Road, Southeast ATLGA. You know the place.
Yes,
you need
sir.
to not go back there anymore.
Yes, sir.
Whether it's to get gas or buy a soda, go to a different gas station.
Yes, sir.
Anything else, Ms. Hall, in Mr. Broughton's case?
That does mistake, man.
Mr. Webb, last thing I should say before I ask Mr. Webb, this sentence is parole eligible. Just to remind you, where we are right now, parole eligible. After trial, doesn't sound like it will be. Mr. Webb, do you have anything you want to add?
No, Your Honor. I thank you for the consideration given to my client. in the sentencing.
Mr. Broughton, normally we pass around the indictment, everyone would sign. I wouldn't, but you and your lawyer and Ms. Hall would. But we're trying to do things electronically. Do you authorize me to sign your name on the indictment?
Yes, sir.
Okay, Mr. Webb, may I sign for you?
Yes, sir.
And Ms. Hall?
Yes, sir.
Okay. Mr. Broughton, any questions about anything we've done?
Just one question. When I went to my preliminary hearing on just the aggravated battery, I wasn't charged with aggravated assault with aggravated battery. It was just aggravated battery. I just had one charge. But Judge Rickman, I think she over there, she had put it in. She was like, I want to throw this case out because the attorney that I had at the time, he was like, if
Are you talking about the broken nose case?
broken nose.
Okay, and you may be, I'm not talking about that case.
No, I want to talk about the case. She was just saying that it was part of, she said she gonna recommend that it ran concurrent in with this case. So I didn't.
Okay, and that's exactly the kind of thing Mr. Webb can explore now. There's someone in the DA's office he can talk to say, look, Mr. Broughton just got a 5-year sentence. What can we do with this other case to either get rid of it or have it run concurrent? And if the state is willing to what we call accuse it because you waive indictment, I'm happy to get in the middle of that and handle it. But Ms. Hall would need to be willing to do that. And I have no idea the status, but you've got time to work through that. You all can come back here if the facts of that case support it. I don't know anything about that case. It could be that the man almost died. It was his nose was shoved back into his brain, and I don't want to commit to anything. But if it is a broken nose and there are all sorts of mitigating circumstances to it, and it gets accused, happy to deal with it, or at least let whatever other judge out there who gets it know. Here's what we talked about. Okay. Thank you, everyone.
Thank you, Your Honor.
Good luck, Mr. Broughton.
Yes, sir. One more question. I was just gonna ask, I'd get some paperwork or something showing where, like, would you say about that 9 do 4 or the 10
Yes.
do 5?
So when we get word as to how the sentence flows, it will ultimately get loaded into the docket, and Mr. Webb can get you. We call it the final disposition. It's your sentence.
Yes, sir. So I just want to have something in black and white showing that it's there. So
Yeah.
if it's
And so you can get it once it's in there. Mr. Webb can send it to you.
Will he
Okay.
be advised about reporting for probation after does Ms. Crawford need to get involved now or?
Let's ask. I don't want him to leave before then. Ms. Crawford, how do we handle this? Mr. Broughton's already on probation and he's going to be in custody for a little bit. What do you need to share with him?
Since he's already on probation, I won't need to take any information from him. I will tell you after your release date, 48 hours, you report to the Clayton County office where you're already on probation and for that office.
Yes, ma'am.
Okay.
Your Honor, I apologize. Probation was bothering me at some point. Did the defendant actually accept the non-negotiate your terms of now? Okay.
Yes.
I didn't hear that part, so I just wanted to make
Okay.
sure that was on the record.
Yep. All right. Thank you, everyone.
Thank you, Your Honor. Good luck to you, Mr. Broughton.
Thank you, Mr. Webb.
You're welcome.
So
Thank you.
you bet. Stay safe.
Yes, sir.
Retta Moza is going to be a plea at 4. That doesn't concern you guys, but Ms. Patel will be back. Mr. Monsiagli will have an interpreter, et cetera. I'm going to be out here at 3 for a hearing. I don't know if the lawyers it's a civil hearing, so it may just be all Zoom, but I'll be out here at 3. And then at 4, a gentleman, and he's not going into custody. He's going to take a plea. He'll be back.
He's not going in custody today.
Correct. Whatever he's getting, he's leaving the same way he came in.
Oh, okay.
So we'll need a deputy here for the plea. Yeah. It's the guy with the beard who looks sort of like the most interesting man in the.
So he gonna probably go in at another time.
I don't think he's going in. I think that they have reduced this, so he's not going in. But the state will reveal all when Siri Patel is back.
Judge, I do have a question because the Zoom call, this one is going to end at 2:30.
Yes.
Then you're going to be on another Zoom call. So, and it goes till 4:30. So I'm trying to figure out how you want us to get on the call for the plea.
So could people not join the 3 o'clock? And could we?
We can. I
Yeah,
can
and-
just,
And can we extend it? I don't know how that works. Is there a way to extend? Monica set it up. So if she could extend it, let's just extend the 3 o'clock to 5 o'clock. And then all the machines will be working here. So you don't need to share the link with anyone. You and Ms. Rivers can just, I'll share it with her, although it's on your Outlook, it's on Ms. Rivers's Outlook, the link. So I think we
I
should.
think the only one is Miss Crawford. I think that would be the
Okay,
only
we can
person that I
share it
need
with
to share
her.
it with.
Yeah.
Okay, will
Great.
do.
All
Thank
right.
you.
Thank you.